came in, uh, pretty much you just go straight to Miss Brown and her mom's with her.
Yes, sir.
You spoke to Corporal Provo for just a minute and then went to Miss Brown. And then she ultimately signed the implied consent.
Correct.
Right. And tell me again exactly how that went once she signed that form. Was there a phlebotomist in there?
I don't remember if the phlebotomist was already in the room or if we had to wait for the phlebotomist to get there. But
Okay.
at some point, the phlebotomist came in and drew the vials.
Okay. And what exactly did you observe when they were doing all that?
Just the phlebotomist filling the tubes up with blood.
All right. And and then I think your testimony was you took it, put it in the evidence locker and.
Correct.
Now, and that, for the purposes of that night, was more or less that was more or less your involvement in the investigation, using that blood sample. And then you were, later you were present when Miss Brown gave the Miranda interview, right?
Yes, sir.
Okay. And she said that she had eaten at Xander's, her and Mr. Brown had eaten at Xander's Pizza, right?
Yes, sir.
And she told you she'd had a beer
Correct.
and an appetizer, a salad, and a personal pizza, right?
I believe that's what she said.
And then they went to the Oktoberfest. Now, Captain Christian, you noted that Captain Christian had noted in the interview that Miss Brown had a alcohol beverage bartender card.
Yes.
And so, and that would imply that she had some sort of training in that, right?
Correct.
And in her opinion, she wouldn't have cut herself off. We heard that, right?
Yes, sir.
And then Captain Christian wanted to do due diligence, and she was cooperative, right? It was a
Yes, sir. I mean,
Cooperative
totally
interview.
voluntarily, she came in and cooperated fully.
and to do your due diligence, you and Major Christian, y'all were going to talk to every witness that you could, right?
Correct.
Because, and I think this, I don't want to talk out of context here, but I think it says that if you do your due diligence, if the witnesses say you're fine, then that supports that theory, right?
Can you say that one more time?
He was talking about a witness, and he said if the witness says that you were fine, then that would support that theory. Talking about when y'all were looking for other witnesses, like, I don't know, their name, Katie Joe, I think was one of them. But did you hear that where he says if they said you were fine, that would support that theory? Now, did you and Major Christian interview a Miss Sue Connor?
We did.
Okay, and that was later on as well, right?
Yes, sir.
Okay. And she an interested person?
You can say that.
Okay. Not very tall either, huh?
No, she's rather on the short side.
Okay, all right. But you guys interviewed her later. Was that the same day or was that later on? Or do you know?
I believe it was later on. I don't remember if we finished up our interview with Miss Brown and then went, or if we went a day or two later.
Okay, fair enough. Now going back to Miss Brown's interview, she said she usually didn't take that route and she wasn't familiar with Walnut Street, right?
That's what she said, yes, sir.
And are you aware whether or not there is a speed limit sign? Let me back up. If you're leaving Main Street, you have to back out and then point yourself towards Walnut Street, right?
Right.
And then you make a right on Walnut Street.
Yes, sir.
Are you aware if anywhere on that route, if there's a speed limit sign between there and where the wreck happened?
Now, it's been a while since I've been on Walnut, since I've retired, but if memory serves me right, after you go through the intersection of Walnut and South Charlotte, there is a speed limit sign on the right-hand side.
Okay, but you're not 100% sure?
I'm not 100%
Okay,
sure.
fair enough. All right. And So, and then we're talking about what went into this crash. Major Christian said that speed is definitely a factor, right?
Correct.
And he said, but he doesn't know what causes that, right? Okay. And you, I don't know if it was you or he that, but Ms. Brown was upfront and honest with you guys, right?
Yes, sir.
Okay. And she admitted that she'd used some marijuana the day before, didn't she?
She did.
Okay. And again, with the black box, and I'm using Major Christian's words there, but it says it doesn't tell us what happened inside the car,
Right.
right? Okay. You have one moment, Your Honor?
You may.
Thank you. I'll tender the witness, Judge.
Mr. Arnold, anything further?
No redirect, Judge.
Retired Sergeant Summerer, you are released and you may return to enjoy your retirement.
Thank you, Your Honor.
Mr. Arnold, you may call your next witness.
Judge, the state of Tennessee calls Major Todd Christian to the stand. And again, I apologize, Judge. Apologize once again, Judge, for moving around. How's it going this afternoon, Major Christian?
Fine, sir.
If you would, please tell us who you are and tell us what you do, and spell your first and last name for the court reporter.
Todd Christian. It's TODDCHRISTIAN. I'm currently a major with the Dixon Police Department.
Now, what do they got you doing these days?
So I assist with the day-to-day operations with the department, and I also serve still as our lead reconstructionist.
And when you say reconstructionist, do you mean crash reconstructionist?
That is correct, sir.
How long have you been doing that?
Since 2010.
Now, I'm going to pass up a document. Do you recognize the document that I passed up to you?
Yes, sir.
Is that your resume, or what is sometimes called a curriculum vitae or CV?
That is correct.
And is that more or less up to date to the current time?
As best as I can recall, yes, sir.
Okay. And just to touch just a couple of points, tell us about your basic and advanced crash reconstruction training, and then tell us about, you yourself are a trainer. Tell us a little bit about that.
So my initial training was 40 hours at the Tennessee Law Enforcement Training Academy. And then I attended an 80-hour advanced crash class after that, somewhere in 2008. Then in 2010, I attended another 80-hour class to become a reconstructionist. And part of that reconstructionist, you had to reconstruct a crash to perfection in order to get your certificate. So half a day you do theory. So it's kind of like just recalling some facts, and then you reconstruct a crash. It takes another 4 hours to do a full, complete reconstruction for that. And then they grade it. And then after I received my certification as a reconstructionist, I started teaching with the Tennessee Highway Safety Office in 2010. And I still currently teach with the Tennessee Highway Safety Office today, teaching crash investigations from basic to advanced to reconstructionist level.
Now, have you ever been deemed an expert in crash reconstruction by a court here in the state of Tennessee?
No, sir.
Okay, so this will be the first time.
That's correct.
Your Honor, I would like to submit Major Todd Christian of the Dixon Police Department as an expert in crash reconstruction.
Mr. Baker? No objection. Ben says no objections, so this will be the first time it happens, but we expect it to happen again. We will certify Major Todd Christian as an expert in accident reconstruction.
And Your Honor, I would like to submit his CV as the state's next
That is
exhibit.
the next exhibit 10, is that correct?
Now, Major Christian, did you perform a crash reconstruction and accident reconstruction for the case that we're here about today from October 3rd, 2020?
That's correct.
Now, before we get into the details in the PowerPoint that you prepared, run us through all of the things that you did as part of the investigation.
So when I received the call, I made some phone calls on the way to Sergeant Summerhour, advised him of what we was responding to, that we would need his assistance to come out. Once I arrived on the scene, I walked through the scene to kind of get a survey of what all was needed as far as equipment, and just get a general basis of the actions that took place. As I got out of my patrol car, Miss Brown was in the back of the ambulance. You could tell that she was obviously upset. She was screaming, had her phone in her hand. I walked past the ambulance to the vehicle that was resting in the middle of the roadway at Walnut Street. I walked around the car. I seen the deceased laying partially in the driver's seat and out into the roadway, where our medics had tried to pull him out to make sure that they couldn't revive him. I met with Sergeant Chandler and spoke to him about some witnesses, and then I started taking photographs, marking the scene for evidence, talking to some of the witnesses to try to get a better understanding about the crash, and then making marks, taking there again some more measurements to determine the speed based off of the yaw marks, or what we call striation marks there on the sidewalk.
Okay. And did your investigation also include checking Ms. Brown's vehicle for recalls that could or could not be relevant?
That's correct. We went to, there's a website, it's called safercars.com, where you can enter in the VIN number of that particular vehicle, and it will show you any open recalls on those vehicles.
And did you also examine the roadway and the vehicle under daylight conditions as well?
We did, yes, sir.
Now, did you prepare a PowerPoint presentation to run us through this?
I did, yes, sir.
Okay. If I could have the Okay, so if you could please describe for us what we're looking at here. I understand it's not to scale, but explain
Right.
to us.
This is a not to scale drawing. This was taken from the crash report that Sergeant Summerhour completed. But you can tell that Miss Brown, or the vehicle, the Ford Focus, was traveling up West Walnut Street, where it left the roadway, got onto the sidewalk, and it started into what we call critical speed yaw, and then impacted the utility pole, and then it rotated around the utility pole, done a 360 on the roadway, and then came to rest just north of those crossroads. This here, sir, is just a Google Earth image that we took off the web. Down where your mouse is, that's the crossroads of South Charlotte and Walnut Street. And Ms. Brown was heading up on it, as you're indicating with the mouse. And then it turns into that left-hand curve where the sidewalk right there, where the mouse is pointing, is where she went up on. I went into that critical speed yaw, and then it struck that pole, and then just continued on past that about where your mouse is. to final rest. This, there again, is just a Google Earth image looking up the roadway, up West Walnut, so you can get a street view of that same roadway and the curvature.
And would this be the direction of her travel?
That is correct, sir. This is just a closer into that curve, where in the same direction that she was headed. And then the sidewalk to the right in that house is where the sidewalk that she went on, and then she struck that particular utility pole. This is just a picture that we took the following day, just there again to show the construction of the roadway. Just a closer picture.
And again, once again, this is the sidewalk she got onto, and that's the pole that she hit.
That is correct. Just showing you a little bit closer into that, because we always start back and then work our way into our crime scene. But that is where she's entering up onto the sidewalk and then striking the pole. Here's a picture of the sidewalk. You can start seeing some tire marks on the sidewalk. You can see that there's a distance between the one to the right and one to the left. That's where it shows an indication that she was in what we call a critical speed yaw. The next picture, I believe, sir, will show that there's some striations in there. I think if you advance it one more. So those sideway marks that you can see, those are what we call striations. That would indicate that the tires of her vehicle was side slipping and free rotating. There was no input by the driver.
Now, you've said it a couple times, but I'm going to ask you to tell us what it is. What is a yaw?
So a yaw, there again, is where your rear tires start tracking to the outside of your vehicle. As I gave the explanation or example to Ms. Brown on the day of the interview, if you've ever been to Taco Bell, and whenever you place your order at Taco Bell, and then you go to make that left-hand turn, where your rear tire typically will hit the curb. Under normal conditions, your rear tire tracks to the inside of your vehicle. So that's why you hit or curb your back tire. In a critical speed yaw, you have two forces. You got some centripetal and some centripetal forces that's acting upon your car. One's pulling out, one's pulling in. And as long as those forces are equal, you can negotiate around the curve. It's going to hold you in the roadway. Everything's going to be the way it should. If you break outside those forces, one exceeds the other, then you'll get into that critical speed yaw. And that's where your rear tires will start tracking to the outside. So your car will start sliding. And there's no input by the driver. So there's no braking, there's no acceleration. As we say in the crash investigation, Sir Isaac Newton starts driving your vehicle at that point.
So once I'm in a yaw, my input doesn't matter. Is that fair?
So it would. I mean, if you started braking or if you steered or done something else, I mean, you could probably recover out of it, but it's going to take a little bit to do that.
And these marks are part of what proves what you say happened.
That's correct. A lot of times cases that we look at don't have the striations. And so you can't use what we call the chord and middle ordinate measurements to be able to determine speed from that particular mark. That's just a picture of the pole. And then down at the bottom, right there at ground level, you can see that there is some separation from the impact from the pole. So it shifted that pole.
Now, when we do have one of these yaws like we have in this case, you mentioned the chord and middle ordinate. What does it allow you to do in terms of determining a vehicle's speed?
So the yaw marks are going to leave a curved mark evidence on the roadway. And so we can take a measurement, what is known as a chord and a middle ordinate. Anytime that you're dealing with a circle, you can go anywhere within that circle and take a chord, a straight line between, and then go to your middle ordinate to get a radius. That'll tell us what the radius of that curve is. And then you can take the radius and then you can plug that into a known speed formula. And you can come up with the speed at the time of that yaw. So where she's made the yaw marks on that sidewalk, we took a chord and middle ordinate We plug that into the radius formula, and then we plug that into a speed formula to determine her speed at that particular point. This is just showing from the pole to final rest. And inside there, it's kind of hard to see here, but you can see some rotation marks or yaw marks, skid marks that would show the direction of the car. So it would go across the picture up towards that sign. That's just pointing out the final resting positioning of the vehicle. This picture was taken at night, and that's indicating the final resting position of the vehicle the night of the crash. There again, this is from the pole to that final resting position. You can kind of pick up some of those skid marks there. It kind of indicates the way that the car was rotating after it impacted the pole. Just another picture from the pole into the final rest. This was taken from overview. We was on the ladder truck of the Dixon Fire Department, and we was able to take a top view, and it kind of points out a little bit more evidence showing the tire marks the night of the crash.
And is this also debris that had come off the vehicle?
That's correct, sir. This is the sidewalk the night of.
And I believe
There's your marks the night of the crash, so you can still pick those up pretty decent. There's the pole. Part of the door is laying right there beside the pole, and then the light that was up on the pole. Whenever she impacted the pole, the light, the street light, come off the pole.
And when did the light? Is it one of those new halogen ones?
It was one of the older style lights that had the halogen bulb in it. Correct.
Sorry, I meant old. Did you ever determine? A lot of the folks had described 2 collisions. Did you ever reach an opinion about what the multiple collisions might have been?
Yes, sir. Through my investigation, I look at all the parts of the car, the evidence on the roadway, the evidence that's presented by the vehicle, and I determined that she only impacted the pole. What I feel like, in my opinion, the other witnesses saying that they heard another crash, I think that's at the point that that's where that lamp come off the pole, and that's where that halogen bulb busted. Because I mean, it's a huge bulb, and whenever they explode, I mean, they're going to cause noise, and so that may be here what they heard. Same picture, just back a little bit further. Whenever we're looking at those evidence.
And
I'm sorry, sir. This is just showing me pulling a cord in middle ordinate to be able to get the radius and then plug that into a speed formula. This is the tag that represents that particular vehicle. This is the passenger side of the vehicle. Up towards the front, you can see where initially kind of the impact area with the pole. The tire you can see is busted off the rim. If you was to zoom in on that particular picture on the front, you would see some particles of the pole, not only in the lug nuts, but between the separation of the wheel and the tire. And then you've got the door where Mr. Brown was sitting as a passenger, where that absorbed the majority of the impact. And then it rotated on down or slid on down the pole where it come off.
so do I understand correctly that the front right wheel is actually part of what struck the pole?
That is correct. This is just the front of the vehicle. There again, where you can start seeing some of the impact area on the front, and then it's as it goes down the passenger side of the car. This is the driver's side of the vehicle. You can see that there's no real damage to that particular vehicle. This is the passenger side of the car towards the rear quarter.
And when you say sliding, what created all this?
To where it's sliding down the pole, and then it'll start rotating around that once it gets past that area. Your vehicle has what we call center of mass. So it's roughly, if you can look where your stereo is in your vehicle, or where your center of your dash is, that's about where your center of your mass of your vehicle is. So when you have an impact that is close to your center of mass, it's not going to really rotate that much. So the further you get away from that center mass, which here you have center mass is past the right side of that picture, but as it gets further away from it, it's going to start rotating around its center of mass, because we look at that as what we call a moment arm. So the longer that moment arm is between center mass and the back of the vehicle, it's going to be easier to rotate that vehicle. The best example I can give is if you watch a cop show and they talk about a pit maneuver where the cops kind of push the back of a car, or NASCAR racing whenever they talk about Rubbins racing, and then they tap the back of that car and the car will spin out. They're so far away from center mass at that point, it makes that car easy to spin. So that's where you get some of that rotation. This is just showing there again, that center part or area of the door on the passenger side. And this is the front fender there again of the vehicle. There again, if you zoomed in tightly on that front wheel, you could see some of that debris from the post stuck between the wheel and the tire. This picture is the driver's side, where Miss Brown was wearing her seatbelt. After a crash, the seatbelt will lock into place. And so if we needed to say who was driving, we could actually put that driver back in the vehicle and the seatbelt will latch back around that particular person. So it locks out. So it's an indication that Miss Brown, or the driver in this case, was indeed wearing a seatbelt. This is the passenger side of the vehicle. This is what we call stowed away. So whenever you get in your vehicle to leave this afternoon, you have to reach up there and grab your seatbelt from a stowed position. And then you pull it across and it would lock into the latch mechanism. So on this particular crash, there again, it locks in place. So you can physically grab a hold of that seatbelt and it will not move. So it's locked in place, indicating that Mr. Brown was not wearing a seatbelt. This is showing the head strike area where Mr. Brown left the seated position and struck his head there on the roof line area of the car.
And does this correspond to the main injury that the medical examiner described in the first day of testimony?
Yes, sir, I would believe so. This picture was taken at Christie's Towing, where we towed the vehicle to. We had THP, the Tennessee Highway Patrol, come out and extract the data from that black box. We don't have the capabilities to actually get that. We have to contact the Tennessee Highway Patrol because they have the computer software and things to extract that data from the event data recorder. So these pictures are just showing that the day of that we started to get the Tennessee Highway Patrol there, that nobody's been inside the vehicle, because after we got finished with our investigation, we shut the doors to the vehicle and we placed the evidence tape on all creases of all the doors, the best we could. So this is just as you go through those, sir, there's just pictures showing that the evidence tape is still in contact. It's not been broke. And this is all on the driver's side of the vehicle. That's the rear door. And you'll get to the rear hatch. There's some evidence tape that's placed there. And then we'll move to the passenger side. It's kind of hard to secure a lot of that because it was missing the window and things, but we did put evidence tape over it. And then the front of the car and the evidence tape that on the hood that indicates that nobody's been up under the hood of that vehicle. And then that's just the crash diagram again.
Now, you mentioned performing that cord middle ordinate measurement.
Correct.
What speed did that tell you she was traveling at the time that she was in that yaw?
So at the point where I took that the first measurement of the cord and middle ordinate, and I'm trying to recall from my memory, I'm thinking it's somewhere around 56 to 58 miles per hour-ish. And then to back that up, what we do is to make sure that they are truly in a critical speed yaw, we'll take a second measurement. So we have to go within the first third of that critical speed yaw and make that measurement. And then after that, we take a second measurement of same steps, chord, middle ordinate. And then that would show us that her speed should be decreasing at that point. So the first measurement, like I said, I think it was between 56 and 58-ish miles an hour. And I think the second one was around 53, 54-ish miles an hour. So that would indicate to us as reconstructionists that she is in a true yaw and that there's no input by the driver.
And so does that mean that based on the measurement, she was going 56 to 58 miles an hour at some point?
Yes, right at that point, where we took the chord and middle ordinate, that is the speed at that particular point.
Okay, and what is the speed on that road?
30.
And then, hold on, I forgot what I was gonna ask. Oh, you mentioned critical speed. So I wanted to ask you what you mean by that.
It's where the car itself, we look at the car itself. I mean, there's obviously cars that can go faster around those particular curves. You take a Corvette, for an example. It's a little bit lower profile, a little bit wider tires. So it'll be able to negotiate that curve better or faster. But if you take another vehicle like a Caravan or something like that, it's not going to be able to negotiate it the same way. So that's what we look at when we look at the critical speeds of the vehicles.
So is the critical speed of a curve, is that the fastest that particular vehicle could negotiate that curve?
Yes, sir, before it breaks outside the forces.
Okay. So when you say that she was at or above the critical speed, what does that mean?
She is going faster than what her car would allow her to go at that particular point. I mean, she could, she'd seen, well, I don't know what she's seen, but something indicated that she had to pull her car back to the left to jerk it. If you're going down a straight highway and you dump off the side of the road, or you drift off to the side of the road, if you jerk your car too fast, you could actually break outside those forces depending on the speed of the car. And so that's what happened in that particular case.
Okay. And then finally, you mentioned obtaining the data from the CDR.
That's correct.
Are you able to read and understand that data?
I can read it, yes, sir.
Okay. Did that support your measurements from the roadway?
It did, yes, sir. It indicated within the tolerance that's given, was able to verify at that particular point that her speed matches my speed within a certain percentage, about a 2%, 3%.
Okay. All right. Thank you very much. Those are my questions. Oh, actually, let me submit as an exhibit the PowerPoint presentation along with the photographs. And then I've got a collective exhibit of the photographs. I believe there are 40 photographs here. I've already shown them to defense attorney or whatever.
This would be collective exhibit 11.
Oh, I guess we ought to make the digital copy maybe a different one, Your Honor. So if. Oh, okay, thank you very much, Major. I'm sure Mr. Baker will have some questions.
Major, since we don't have much disagreement, I just want to clarify a few things. Y'all basically means that car is in an uncontrolled slide.
That's correct.
All right. So for trying to simplify the situation, because, I've looked at the data, telemetry data, and you have too. I think we're agreement. You tell me if you agree with this. When that this Brown come and the car started up on the sidewalk, at that point, obviously sliding at some point.
That's correct.
And then, according to the telemetry, the steering wheel angle changed. It looks like she went to correct it and overcorrected, and then began to rotate. She's shifted the entire balance of that car, and that slide from one direction changed, and she starts rotating.
That is correct.
All right. So the cause of the accident is the overcorrection on the sidewalk. Would you agree with that?
I would agree that that is a portion of the causation of that crash.
Well, independent of speed, of course.
Correct.
Ultimately, speed's a component. And then I've got up here, I'm already in an uncontrolled slide. I try to correct it. And then I upset the balance of the car and put it into a worse slide.
She would have had to start correcting that prior to going into that slide.
Right.
So she would have seen that she was going to run off the roadway, or that you dip your car off the side of the roadway, and then at that point you make that overcorrection, and then that's when your car exceeds those forces, and then that's when you would start that particular yaw.
And when that yaw or slide, as I like to call it, when that slide occurred, then I'm uncontrollably. I've lost control of the vehicle. And that force, that inertia from that slide puts me into that pole. Are we in agreement?
If there's no other input by the driver, yes.
Because I couldn't tell. The only input I saw was a brief at 2 seconds before the crash. There was a brief tap of the accelerator. That was the only input I saw. And correct me if I'm wrong, if you saw something I didn't see. But I don't think that there was any input once the correction and the slide took place.
Right. When she was in that critical speed yaw, there was no input by the driver, by the evidence of the roadway and the evidence of
And if we can you, Mr. Spratt, can you put the photo back up on from the impact where Mr. Brown hit his head?
We can switch to
Has to be.
Where Miss McKinney was.
Talking to a guy who could not ever figure out how to watch and record something on a VHS recorder. So.
All right. Now, this picture, this is, I think we're all in general agreement. I don't think there's any disagreement. This is the fatal blow for the passenger, correct? Where he struck his head.
That is correct. That is where he struck his head.
Now, I want you to look here on the, what's the B pillar where the seatbelt is
That is
located.
correct.
Had that been fastened, that is, would you agree that's a shoulder lap combo belt?
That is correct. That is a shoulder and a lap belt.
Right. And that controls two angles for an occupant. Lap belts up and down, so you don't exit the vehicle. And the lap belt keeps you from lunging forward, correct?
That is correct.
Is your opinion that had he had his belt on, he probably would not have died?
In my opinion, had Mr. Brown had his seatbelt on, there's a chance that he could have survived this crash. You take any component and you change any component within this crash, there's always a chance that something else could have occurred in the crash. Just simply changing one factor.
Well, Major, you would agree that the medical examiner said the fatal blunt force trauma come from the head there.
That is correct.
All right. So had he had that lap component on, he would not have went vertical and hit that. Would that be a fair statement?
That would be a first thing.
All right. No further questions, Judge.
Mr. Arnold, any redirect?
In your expert opinion, if the vehicle hadn't struck the utility pole or any other object, would Mr. Brown have survived?
Yes.
That's my redirect.
Since I didn't object to that, I'll follow up with it. Had that pole not been there, would Mr. Brown be alive today?
That's correct.
No further questions. Right.
Thank you. You may step down, Major. Mr. Arnold, you may call your next witness.
Your Honor, the state of Tennessee calls TBI Special Agent Forensic Scientist April Bramlage to the stand.
Madam Clerk, before the good toxicologist arrives, would you mind reminding me what exhibit is the alcohol toxicology request form? Is that exhibit 6? It's exhibit 7 then?
No, that was your ID exhibit only, everybody.
It's the only one we marked as ID only. Raise your right hand. You solemnly swear from the testimony you're about to give in this case to be the truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you.
What you're looking for?
Is exhibit 5 a yellow piece of paper?
Form, it's an ID only. Is this what you're looking for?
It is not.
The other exhibit 5 is a fund draft.
What are you
You were
looking for?
looking for the Tennessee Bureau of Investigation Forensic Services Crime Laboratory Alcohol Toxicology.
No. Alcohol toxicology request form, the yellow.
That is 7.
Oh, 7. Okay, I'm sorry. Thank you. If you would, please, tell us who you are and what you do.
My name is April Bramlage. I'm a special agent forensic scientist at the Tennessee Bureau of Investigation in the Nashville Crime Lab in toxicology.
And how long have you been employed in that capacity?
Just at 17 years.
Now, I'm going to pass up a document and let me know whether or not you recognize it.
Yes,
Is that your curriculum vitae?
it is. It is my most current one, yes.
Okay. Your Honor, I'd like to submit that as the state's next exhibit.
Working as exhibit 13.
Now, have you previously been recognized as an expert in forensic toxicology here in the courts of Tennessee?
Yes.
Do you have any idea how many times?
Today is 90.
Now, have you also been certified as an expert to testify in the courts of the state of Tennessee regarding the general effects of alcohol on the human body?
I have
Do you know how many times you've been qualified as an expert in that regard?
at least half of those 90.
Your Honor, I would like to submit Special Agent Forensic Scientist April Bramlage as an expert in forensic toxicology and an expert on the general effects of alcohol and intoxicants on the human body.
Any questions from the defense? I'm going to allow, ladies and gentlemen, the procedures that the court follows is that when someone's being offered as an expert, both sides get to ask questions to shine light on whether or not that person should be or should not be qualified. Defense will have an opportunity.
Bramlage, I'm a little bigger. Have you ever been certified as an expert or offered and certified as an expert other than as an employee of the state of Tennessee?
In toxicology?
Correct.
No.
So the only certification or the only expertise you have is in testifying for your employer.
Yes, I'm a forensic scientist, yes.
Okay. And do you have any publications?
I do not.
No publications? These qualifications, would you be qualified to teach forensic toxicology, say at Vanderbilt?
Oh, I don't know what their qualification is. I have taught high school biology.
Well, I'm talking at a college or a professional level.
I have a master's degree, so if that's what they require, then I would be able to do it.
All right. You would agree with me, Vanderbilt requires PhDs to teach that
I have
level.
no idea what Vanderbilt's requirements.
Have you ever taught any of these classes for anybody other than your employer?
I have taught lectures and topics on alcohol. I've also taught topics on the combined use of alcohol and THC and the effects on driving at local, state, regional meetings.
All right. Do you have any studies that would back up that combo of alcohol and THC effects on driving?
That I have personally done? No.
Can you point me to a study that would say that?
I can point you to several, yes.
Okay. Since the since the 2000 and say 2017 NHTSA study said that a toxicologist cannot testify to that. Do you have anything newer than that?
What are you speaking about? Testify to what?
NHTSA was chartered with doing a report to Congress in which it said one of the problems we have with THC is no
You're using
toxicologist.
acronyms. For those of us who are not in the middle of your conversation, would you explain more fully what those acronyms stand for?
The National Highway Transportation Safety Administration, NHTSA is what we refer to it. Is that correct?
Yes, that's what it is.
All right. They were commissioned to do a study for Congress where
Okay.
they were asked to say, what is some of the problems with marijuana and marijuana per se laws?
Yes.
And they said, the problem one is there is no data and we don't have a toxicologist cannot testify to at a level THC would be impairing. Are you familiar with that
Yeah,
study?
and that is a correct statement. I
Okay.
cannot take a number and correlate that to a THC impairment, no.
Okay. All right. So you're familiar with that study?
That and subsequent studies reinforcing that, and that the oversight, the federal oversight committee that we have as toxicologists called OSAC, stating that no, we cannot do that, and we cannot perform retrograde extrapolation on those types of drugs.
Ladies and gentlemen, step across the hall, please.
My last question. That was going to be my last question.
I can never be sure.
True.
Okay, what I wanted to clarify is that you're asking a lot of questions regarding the THC, which she has said she's not, I don't know if the state is offering her as an expert on anything other than forensic toxicology and the effects of alcohol. Are you offering her for any effects of marijuana?
No, she cited that she
Yes,
didn't give a
I'm
lecture.
talking to Mr. Arnold.
Oh, gotcha.
So
She's talking.
when I point, that means I'm pointing at this guy. So
Your Honor, I was going to ask
Mr.
this.
Mr. Red Shoes back there, I need to ask that question.
Thank you, Judge. Your Honor, Special Agent April Bramlage did the alcohol analysis in this case. Special Agent Melinda Quinn did the THC analysis in this case. I was planning on asking Special Agent Melinda Quinn about the THC and Special Agent April Bramlage about the alcohol.
That's what I thought. And Agent Bramlage has testified more times than I can remember in front of me in other cases. So I just want to clarify, I didn't think he was offering her for that purpose. So
Once we're not getting into THC, I'm good.
all of your questions were kind of irrelevant. So let's bring the jury back.
They never tell me in advance.
Okay. I just would rather address that outside of the jury's presence,
Right.
so we don't get into an area that's not going to be. All right, some of the jurors are using the restroom, so we'll give them a minute to finish. Are you going to ask any other questions when the jury comes back? Then if you would, just let me address the jury. I don't want to make it appear that you got cut off for, some inappropriate reason. So. How many times have you had to testify this week?
I've been okay this week. Been all right. Thank you. I think it's actually the first of 2024 right now.
Oh, really?
Yeah, been a little
Wow.
slow for me.
Agent Bramlage has testified in how many counties that you hit me in several different counties.
sir.
I think you've been here before too. though,
Yes,
right?
sir. Yes, sir. I think I've sat in your court more than anybody.
I'm not sure that's a good thing for either. you. That sheet, I don't count heads, I look for 2 empty chairs when you all get sitting down, so that's how I know that everybody's here. Ladies and gentlemen, before I ask you to step out, I just wanted to clarify the purpose for which the state was offering Agent Bramlage. And in your absence, the state advised that they are only asking that she be certified in the field of forensic toxicology and the general effects of alcohol in the human body, and that she's not going to be asked questions about THC or marijuana. So in that, with that clarification, Mr. Baker, do you have any other questions? All right. So now we will certify Agent Bramlage as an expert witness in the field of forensic toxicology and the general effects of alcohol on the human body. Thank you. Now, Mr. Arlen, you may have it.
Thanks, Judge.
Now, did you perform an analysis in the case that we're looking at here today?
Yes, I did.
And I'd like to ask if she could be shown exhibit number 7. Do you recognize what this piece of paper is and what its use is?
So this is a copy of our alcohol toxicology request form. That's part of a kit that we provide to law enforcement agencies around the state. This is the officer's copy with all of his written information. Once I get it in the lab, there's other written information that we'll put on the bottom.
Okay. And if you will double check, does that correspond to the white top copy form that you have in this case?
Yes, it does.
Thank you. If you would hand that exhibit back. Now, in preparing for this case, did you check y'all's white copy of this form in order to determine whether or not the sample arrived to you guys in good condition?
Yes,
And did it?
it did. It came as a sealed blood alcohol kit, which is that little white box that we provide to agencies. And sealed meaning that the flaps that it comes with had been sealed, had initials, and were not tampered with. And that was noted by the evidence receiving technician.
And were the samples themselves, the tubes, in good condition?
They were. I have no notes of any abnormalities as far as consistency of the sample or any color changes or odor of the sample.
And did you perform an analysis of the sample that was submitted in this case?
Yes.
If she may be shown what I believe is, the exhibit for identification only. It's the only ID only. Now, does the first page or the first 2 pages of that exhibit correspond to your analysis in this case?
Yes, this first page here is a copy of my official alcohol report.
Okay. And is that true and accurate as far as you can tell?
Oh, yes.
Judge, if I could submit the first page of that ID only as the state's next exhibit?
It'd be exhibit 14.
And I'm going to show it to you. So what did your analysis reveal about the sample submitted to you in this case?
So I found the sample to contain ethyl alcohol, at a level of 0.161 grams percent.
I want to make sure I'm opening the right thing here. Oh. And is that an accurate representation of your report with that 0.161 grams?
Yes.
Now, are you familiar with the laws of the state of Tennessee?
A couple.
Are you familiar, what's the legal limit, what's sometimes called the legal limit in terms of alcohol for operating a vehicle here in the state of Tennessee?
Statute is 0.08 grams percent.
And how does this compare with that?
So this is double that value.
Now, are you able to tell us anything about what impact we would expect alcohol in this quantity to have on the human nervous system?
Yes.
If you would, please tell us.
So alcohol or ethanol is a central nervous system depressant, meaning it works to slow communication from the brain to the body and vice versa, from the body to the brain. So how that may appear as far as driving is concerned, driving is a very complicated task. You're doing a lot of multitasking things. Checking the radio, checking signs, keeping your speed, keeping your lane, checking your mirrors. Alcohol slows the ability to do that down so that if you are driving along and car stops suddenly in front of you, it's going to take you longer to realize somebody's stopping, longer to determine, should I hit my brakes? Should I swerve? Or am I okay? Then actually deciding, I think I'm gonna hit my brakes, and then the application of the brakes, that whole cascade of events takes longer with alcohol on board. Individuals may appear with kind of the typical, what you think of with somebody under the influence of alcohol. They may have slurred speech, they may have impaired memory, they may have impaired balance and coordination, they may have impaired cognition and understanding and reasoning. All of these things, the more alcohol that is taken in, the more of an effect that you may see and that alcohol will have on the person.
Now, I notice we're speaking in generalities. Why can't we speak to individuals?
So individually, 0.08 is determined as a statute because at that level, all individuals are considered to be impaired cognitively. If an individual is experienced at drinking and is used to how alcohol affects them, they may be able to alter their gait, where they can walk a little bit slower. Or if they know that alcohol causes them to slur their speech, they may adapt and speak slower, speak more carefully. So that it is possible for some individuals that are more experienced in the drinking to not necessarily look outwardly impaired because they're able to mask those effects. They cannot mask those cognitive effects, the slowed reasoning and the slowed processing. That cannot be adapted for.
Okay. Thank you very much. I'm sure that Mr. Baker might have some questions.
Okay.
Baker, Mr. Baker, you have questions?
Now, do you know how long that sample, or how long it had been between the blood draw of that sample and the crash?
I do not.
If it was established, it was like 2 hours and 45 minutes, would that be concerning to you?
In that the value that I have obtained is the value that was what was in the blood at the draw. The value of blood, alcohol in the blood may have been quite different 2 hours and 45 minutes earlier at the time of incident.
All right, so we're not able to determine what the actual BAC was at the time of the draw.
I would have to have either a second draw or maybe more facts of the case to give a hypothesis.
Right. And Mr. Pratt, can you put figure 1 up? I'm going to give you a generalized alcohol curve, and if you would, I want to explain to the jury why that's important.
Okay.
Can you move that up a little bit, Mr. Spratt? No, there, just move the key's not up. Judge, may I move around in the courtroom?
May you walk around in the courtroom?
Yeah, I want to get over
I
here.
do I have a choice? Yes, you may walk around in the courtroom.
If you could you lead me through on this chart here, what we're looking at?
So this is, I believe, looks like you maybe got it out of the Garriott book. This is a pretty common demonstration of how alcohol makes its way through the body. So you look at the very bottom left corner, that's your BAC is 0 and your time of drinking is 0. As you drink, you're going to absorb alcohol. This is a general curve in that it goes up. The slope of that depends on a lot of stuff. If you're drinking slowly, you're going to have a little bit of a, not that big of a slope. If you drink fast, that slope's going to get a little higher. You have food on board, your gender, your weight, different things can change the slope of that. But that's a good general idea. You're going to go up the more you drink. Then you're going to stop drinking. As you stop drinking, you're going to go up maybe a little bit more and then peak. So that peak is your highest blood alcohol concentration for that time period you drank. And then you're going to go down.
Now, if I can ask you something, I want to interject something here that
All
I
right.
think is important. And you talked about the variables.
Mhm.
This period between absorption phase and peak phase could be 20 minutes or 2 hours.
Absolutely.
Depending on,
Depends on your
certain
drinking
factors.
pattern. Correct.
Okay. So we don't know, depending on those variables, that what that time scale is on the bottom.
No, and that's why there's no digits,
Correct.
no values down there. No,
Correct.
this is
No.
very general.
Right. And I didn't mean to cut you off, but now we're at the peak part.
Yep.
All right, so we've reached the peak part, and at that point, one, nothing's being absorbed in. We're in the elimination phase, and that number starts coming down, correct?
Yes.
So when we have a sample that's 2.5, almost 2 to 3 hours old, we have no idea where we're at on this chart, do we?
Not without knowing some other factors. So I need to know when they stop drinking. Because once you stop drinking, if you notice the backside, the post-absorptive looks pretty normal. That is the same for everybody. It's 0.01 to 0.02 per hour, about a drink. You're going to eliminate about a drink an hour. So if I have a period of time where I know you've stopped drinking and you haven't taken any more, and say a bunch of hours go by, I can assume you were in that post-absorptive phase when the blood was drawn. If I don't know that, or I don't know when your last drink was, we're going to take this, basically, say if I have a known here, we're going to shift to now where it's possible that 3 hours prior, or in that 3 hours, you peaked and you were still absorbing. So it's just like this rotating thing. You take 3 hours and you can go, I was here and here, or 3 hours was I here and here. I don't know that without a second draw or without a lot more information.
All right, so the point I'm trying to make, and I'm going to assume you'll agree,
Yeah.
is we have no idea what the BAC was 2.5, 3 hours before this draw.
Not without knowing some other factors.
Could be lower than 1.6, could be higher than 1.6.
Yes, our typical answer is it could have been higher, lower, or the same.
Right, and would you agree with the medical examiner? I asked him the question, if at 0.16 BAC, depending on several factors, you may or may not have motor skill impairment, and he said that is absolutely correct.
Say that again.
Medical examiner, I asked him earlier, yesterday, at 0.16 BAC, would a person be motor skill impaired? And he said, that depends on the individual. There's no way to answer that.
That's where
Is
that
that
tolerance
true?
comes in. That's where that tolerance comes in.
Exactly. So we don't know whether there's motor skill impairment, and we don't even know what the level is at this point. Is that a fair statement?
I need a lot more information.
Correct. That we do not have, correct?
I don't have it.
Right.
Somebody may, I don't have it.
Would it have been helpful to have the first blood draw at the hospital that would have been less than an hour old? Then we would have 2 data points, correct?
2 data points on would give me a better idea on the back extrapolation, yes.
Right, but we didn't, but somehow we don't have those. So we now have no way of telling what the BAC would have been.
Not without other factors being told to me.
Judge, may I have a moment?
You may.
Pass the witness, Judge.
Mr. Arnold, you may redirect.
Would it help you to know that for the 2 hours and 48 minutes prior to the draw, the person who the blood was taken from consumed no alcohol.
Okay. That could give me a better idea on when they may have been at post-absorptive. So after your last drink, you're gonna reach that peak within 30 minutes to an hour, depending on that prior drinking pattern. If it was a slower drinking pattern, 30 minutes. If it was a very rapid drinking pattern, an hour. So once you reach that peak though, so if we're talking 2 hours and 45 minutes, we'll say that first hour, potentially, they may have been hitting that peak phase. So then the next 2 hours or the next hour and 45 minutes, I know they're post-absorptive. So I can give an estimate of adding 0.01 to 0.02 per hour, going backwards, of what they may have been around that time.
Okay. So if the jury had evidence that the person was in continuous law enforcement and medical custody for the 2 hours and 48 minutes between the crash and the draw, would that help you form an opinion about whether or not their BAC would be the same, higher, or lower than this figure?
Then at that time, it would have been higher because my draw is here. You've got the time in between where they are not drinking, they are actively eliminating. So at the time of the 2 hours, 45 minutes later, they would have been higher. I can give an estimate of a number, just adding 0.01 to 0.02 to each one.
Judge, I'm going to object to the speculation. We're now just guessing on numbers.
Rule, I believe that this question was raised by your cross-examination, and I'm of the opinion that she is simply responding to possible hypothesis regarding the factual basis. As an expert, ladies and gentlemen, experts can be given hypothetical questions to answer if the facts are presented in a hypothetical fashion, and the expert can answer that if it's within their purview or their expertise. So overrule the objection. You as the lawyer, and you as the judges of the facts will be given instruction at the conclusion of the case on how to apply any expert testimony and what weight to give to it. Mr. Arnold, you want to re-ask the question?
Sure. So knowing that there's no consumption for 2 hours and 45 minutes prior to the blood draw, it's actually 2 hours and 48 minutes prior to the blood draw. Okay. Can you give us some, I should probably give you paper and a pen or something, shouldn't I?
No, you're okay.
Okay. Could you give us some ballpark numbers for what the BAC could have been? So let's assume first that we're in elimination the entire time.
Yes, you have to do that,
Okay.
yes.
Which of course we know might be counterfactual. But if the person was in elimination, that is the bottom part of that peak for the entire 2 hours and 45 minutes, what is the range of BACs that they would have been at?
So to make the math a little easier, may I use 3 hours?
Let's.
Okay. So taking that 0.01 to 0.02 per hour and adding that to the 0.161 I have, the estimate would then be a 0.191 to a 0.221.
And if we only had 2 hours of elimination to work with, where are we at our peak?
So then if you're only going to go back 2 hours, six, 0.181 and 0.201. Right now would then be your peak. And that would, I'm guessing, assuming that they were peaking that first hour.
Right.
Okay.
And that is, of course, based on the information that we have almost 3 hours where we know the person isn't drinking.
If that's the scenario, yes.
Thank you very much.
Your thoughts?
Chart back up.
No, it's helpful.
It is. We get the IT back. All right, now, I want to go back to look at this chart here. Now, let me give you another.
Okay.
Let's say the defendant had 8 right before this.
Okay.
All right. so now we're gonna have a very slow or a slower absorption phase for that 2.5, 3 hour period. It's gonna be slow. So even when we peak, if you go back, we're going backwards on this curve to get that number. Mr. Arnold crutched his questions that we're in elimination phase. We're in the going down.
Okay,
That's not true. We're talking going backwards 3 hours where the curve is going down very, very, very abruptly.
it's not gonna take 3 hours to absorb.
We don't know that because she ate. It could
What did
take
she
2 to
eat?
3
How long did
hours.
she eat? How much did she drink?
And how much does she
What was
weigh and
drank?
what's her rate of metabolism and so forth.
Well, metabolism is gonna be the same. You're either, metabolism of the alcohol is gonna be the 0.01, 0.02.
I'm talking about the dehydrogenase in the defendant, how much alcohol dehydrogenase and so forth.
So that is, you're talking her actual liver enzymes?
If you want to get that technical, we can.
I'd
but-
rather not confuse them.
But what I'm getting at is when you're getting in the absorption phase here, you got a slope up here.
Correct, and that's when I was talking about, you got this 3 hour block. We're just moving that 3 hour block. But if the scenario is there's no drinking, unless you have this, what was your scenario?
My scenario is if you ate here at the beginning and I back up 3 hours, that number's going way down real quick. Whereas when you get to that peak, that slow elimination at 1.5 an hour is very slow down. That could take, depending on what your BAC at a 1.6, could take 16 hours to get back to zero. But it doesn't take 16 hours on the slope up. So what I'm saying here is when you're looking at the slope up, the absorption phase, and you're going back 3 hours, we're going in reverse now, that slope is going down.
Judge, is he gonna ask a question? I'm sorry, objection.
Staying as to the form, there's no question in what he's been making a statement, but sustain the objection.
If we're going back in time, that slope is going down very abruptly, correct?
What slope are you speaking of?
If we're going backwards in time on the absorption phase,
Okay.
that number is going down very rapidly.
The number of, you're saying the blood alcohol is going down on absorptive, the number's going up on absorptive.
Well, let me give you an example. This is the start. Let's say we peak here at 3 hours. And I'm backing up 3 hours. That number's going down very abruptly as we go back.
You're stating though that that is the actual curve of that individual. That is not what that curve of that individual is. That depends on what they ate, how much they drank, how long they drank. If you want to get into their metabolism, how their liver enzymes work, are they a heavy drinker? Are they a light drinker?
Right.
That is not representative of all individuals. The backside is pretty representative of all individuals. That front side is extremely variable.
Because that front side is where the big question mark comes back. The absorption phase is where the big question
Sure.
mark is. And that's what I'm getting at. We do not know what that number is, and we have no way of knowing.
You could know it if you knew what the person ate, what they drank, how long they drank, then you would know the slope of that line.
Approximation.
I'm not gonna get that, am I?
Okay, gotcha. An approximation of a slope.
I will say it does not, the only way it takes 3 hours to absorb alcohol is if you are drinking continuously that whole 3 hour time, and then you peak shortly thereafter.
All right.
Therefore, that would be a short slope, right? If I'm drinking over a long period of time, I'm slowly absorbing. If I drink quickly, then it's gonna go like this.
Well, let's talk about some different variables then. Let's say we pull a blood sample at 3 hours, and I'm going to take you through the procedure. You can correct me if I'm wrong. They'll take the individual into the ER. They'll get your sample box with your lot numbers and your back tubes for your blood draw, correct?
I'm not present at any blood draw.
You don't know the procedure for blood draw?
I am not a phlebotomist. I don't know how they do it. I just know that blood gets in a tube and it gets to me.
All right, so you're not familiar, that tube's got anticoagulant in it that's
I know what's in the
important to your
tube,
test?
yes.
All right, so that tube has to be shaken for a certain amount of time, so it's mixed up and all that stuff?
If it is not, I would have noted that, and I have no notes of that in this case.
Okay. So there's no variables in any step along the way?
On the draw,
Right,
I have no reason to believe in this case there was any variable.
but you don't know?
I was not present at the draw, no.
No further questions?
Mr. Arnold?
No redirect, Judge.
No redirect, so Agent Bramlett, we will release you from your subpoena and you may go on about your business. Thank you. Mr. Arnold, you may call your next witness.
Your Honor, it's come to my attention that we might be at the afternoon break portion of the
All
program.
right, well, we'll take our afternoon recess. We'll be in recess for 15 minutes. Ladies and gentlemen, if you'll step across, I want to ask the lawyers a question or two. All right, my question is basically, we had talked briefly this afternoon about the progress we're going to be making, and from this point forward, are you planning on calling one more witness for the state?
Correct, Judge?
All right, and would that witness be about the same length as Agent Bramlage?
Possibly slightly longer, because that witness is going to be testifying about the thing that Mr. Baker seems really worried about.
All right, and so then we have one witness for the defense, correct?
We do, Your Honor.
It appears to me that we're going to be able to finish the proof in this case and we can move forward with closing arguments and allow the jury to start deliberating. Anybody have any problem with that? May mean we have to go a little later in the evening, and if they can't reach a verdict at a reasonable time, then we'll bring them back tomorrow. But I'm just looking to see if we can conclude it today.
Assuming the defense can get their
Any idea about your witnesses?
I'm not sure, Judge. I need to step out and call her. I think she was planning.
Well, we're on break, so do that. And before we bring the jury back, we'll try to go ahead and find out the answer to that question. Okay. Stand recess. Well, ladies and gentlemen, you're going to be given instructions at the conclusion of this case about how to apply expert witness testimony, and what you'll basically have to do in that instruction is to consider expert testimony like any other witness and determine whether or not you find it to be credible based on the training, experience, and the information that's presented. It is basically an opportunity for the state to present expert testimony, and I do find that she is qualified as an expert. So for that reason, your objection as to relevance is overruled.
Thank you, Judge. Did you analyze a blood sample that Special Agent Bramlage had also analyzed for alcohol in this case that brings us here today?
Yes, sir.
Madam Clerk, if she could be shown the remainder of the identification exhibit. Now, do you recognize that the document that the clerk just handed you?
Yes, sir.
Is that your official toxicology report from analyzing the blood submitted in this case?
Yes, it is.
Now, can you tell us what did you find in this blood sample?
So in this sample, I detected delta 9 tetrahydrocannabinol at 3 nanograms per milliliter, 11 hydroxy delta 9 tetrahydrocannabinol at 1 nanogram per milliliter, and 11 nor 9 carboxy delta 9 tetrahydrocannabinol at 46 nanograms per milliliter.
Okay, and if I could publish, if I'd submit that as a state's next exhibit and ask to publish it to the jury using the TV screen.
Exhibit 16.
Okay, is what I've put on the screen here, of course, your signature is there at the bottom, but is this an accurate representation of the report that you just read?
Yes, sir.
Now, this third quantity, this larger quantity, okay, in terms of active intoxication at the time of the blood draw, right? What does this quantity mean?
So the hydroxy, that's a metabolite. That third item on that list is a metabolite. So when an individual ingests THC, that's a product that their body makes. This particular metabolite does not have any activity in the central nervous system, meaning that it doesn't plug into any receptors to cause any reaction. So it's just floating around in the bloodstream until the liver can do its job to clear it out. It's just a result of cannabis or THC being in the body.
Yeah. So for our purposes here, is it fair that we could just disregard that?
Yes, in terms of effects and what it doesn't cause any impairment in the brain.
Now, those first two numbers, are they active metabolites, and what does that mean?
So the first compound, which is delta 9 THC, that is the parent drug. That is the drug that that causes the majority of the effects that you see when you consume marijuana. The hydroxy metabolite, that next one down, is an active metabolite. So it's a compound that the body makes in terms of working to eliminate that drug from its body, from the person's body. But it does have an activity, meaning that it does fit into a receptor in the brain and it causes an effect.
Now, so would it be fair to say that at the time this blood is drawn, there might be some effect of marijuana on this person given those quantities?
There may be.
Now, if marijuana was affecting this person, what would be the impact we'd expect?
So the types of things that you could expect to see after somebody had ingested marijuana changes how the brain functions. So it can cause difficulty in perceiving time and distance. It can cause changes in cognition, decision-making, thinking, that kind of thing. It also can cause changes in learning and memory. Those three things are very important when a person's driving a car. So, for example, maintaining a lane becomes more difficult when a person ingests marijuana. That's one of the prime symptoms that can be seen in their driving, is that it becomes more difficult to stay within the lines of the lane.
And those courses that you attended, did they teach you anything about the combined effect when marijuana is combined with other substances like alcohol?
Yes.
And what did they tell you?
So the combination of marijuana with alcohol can be very, very dangerous. And an individual who has consumed both of those compounds is more likely to be in an accident than with either compound alone.
Now, why is it so difficult to get specific and to get beyond the general?
In terms of the levels.
Yes, and for marijuana.
So marijuana is just a complicated system. It takes very low levels of marijuana to cause an effect. That effect is actually happening in the brain. It's not happening in the blood. We're not able to take a brain sample. We would have to take a blood sample. So it's hard to know what's happening in a person's brain. In addition, individuals who smoke regularly and often and a lot can have low levels of detectable parent drug in their system even after abstaining. So that's why it's very difficult for a state to come up with a legal limit, with a per se limit like we have for alcohol, because it's hard to know how long ago an individual consumed the marijuana and if they are still feeling the effects of that drug, even though we were able to find detectable levels in their system. It was once thought that we would be able to do some math based on those 3 compounds to figure out how long ago a person ingested, and those numbers just don't really play out in real life.
I'm glad that you mentioned that. What, if anything, can you say about the recency of use in this case?
It's really difficult to say anything at all. In many cases, after 24 hours, you wouldn't expect to see these compounds still present in a person's blood after they had smoked and then abstained from smoking. But we can't say that in all circumstances. So it's just, it becomes very complicated.
And in that statement, when you said these compounds, you meant the active ones, didn't you?
Yes, that's correct.
But the inactive ones could hang around for a long time.
They can potentially for a long time, which is why we test for them, so that we are able to see back into time a little bit.
Thank you very much. Mr. Baker might have some questions for you.
Are you familiar, I want to go through, are you familiar with the NHTSA study and the report to Congress on marijuana and the use study that they were commissioned to do?
Yes, sir.
Well, I'm kind of perplexed at your testimony that alcohol and marijuana combined amplifies the effects, because that's exactly opposite of what this says. There's no empirical data that says that marijuana and alcohol combined has any effect, the marijuana itself.
That is, that's not a recent report. There are many, many studies, and it's very difficult to study driving and to know what causes a direct effect on driving and what might be the circumstances or the age of the driver. But there have been many studies that have shown multiple times that even just a little bit of alcohol and a little bit of marijuana together can be more dangerous than either alone.
Well, I want to quote this: toxicologists are not able to provide expert testimony. The specific amount of THC present in a subject's blood or other specimen is definitively associated with being impaired by marijuana and rendered the driver unable to drive safely. Do you disagree with the National Highway Transportation Safety Administration?
No, sir. That's why I think that per se levels just really don't make any sense in really all circumstances for marijuana.
Because the
Yes, sir.
number doesn't tell you anything.
No, not on its own. That's correct.
That's right. So the testimony that there's some synergistic effect between marijuana and alcohol that you just testified is not true.
I don't believe that statement mentioned the combination of alcohol and marijuana. There have been multiple studies that have shown that those two compounds together really make it more difficult to drive a car safely than in any two alone. Individuals are more likely to have an accident with those two compounds on board.
And well, may I approach the judge?
You may.
I'd like to do that study. If you could point me in there where that information is at, I'd be happy to review that.
This is just one single government study. Marijuana has been studied in many different, from many different groups, many different angles, many different studies. We would never just rely on one study to provide the information that we would need for court.
Oh, can I get that back? Well, that's funny because this report was commissioned because the lack of data is why Congress wanted this study. Do you agree?
I think that more data is always useful.
All right. there wasn't enough data to even correlate a number to impairment.
And certainly, I would say that in the years since marijuana has become legalized in many, many states, there is much more interest. Many more drivers have consumed marijuana than ever before. And so there is much, much more interest. And there have been many, 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 many studies that have happened since that report was commissioned.
All right. And you can't even tell me this from that number or that report when the alcohol was ingested or inhaled.
I didn't perform the alcohol testing on this case.
Well, I mean, even the THC, I mean, we don't have, that doesn't give you a snapshot in time either.
That's correct. So anytime we ever talk about any drugs in a driving case, we would really look at them we would ask the jury to look at this information in the totality. So why was the officer in contact with this first person in the first place? Was there evidence of bad driving? Did that person perform standardized field sobriety testing? And if so, what was the results of that? And then the third leg of that information stool that the jury would use would be what drugs were potentially found in that case, and then how would that explain what the officer saw in those circumstances.
Well, it looks like you're getting numbers and then looking to fill in data to justify the numbers is what you just told me.
I'm sorry, was that a question?
No, is that a fair statement?
No, it's always our role to test the sample. I have no knowledge of the case. I was not present during the blood draw. I wasn't present during the person's arrest. I don't know even if standardized field sobriety happened in this case. Simply my role to test the blood and to use our standard operating procedures to develop a report. And then I bring that report to the court, and I talk about the types of effects that we would expect to see with those drugs. And then hopefully the jury can use that information along with all the information that they've been given throughout the trial.
Mm-hmm. Well, one of the effects on marijuana on the central nervous system would be to, according to the data I read here, it causes you to drive slow. Do you agree?
That is something that we've seen in the data. It's an interesting effect that marijuana can sometimes cause a person to drive a little more slowly, whereas alcohol can cause a person to drive more quickly. And it's just an interesting facet.
So let me just sum it up here. The information you're giving us is not specific to Ms. Brown here.
And no, I couldn't know anything about what happened to her in the hours or the days prior. I wasn't present at the blood draw or at the scene of the accident.
So absent field sobriety test, one-legged stand, 9-step walk and turn, and so forth, we don't have anything to correlate whether there's motor function impairment to any degree. When you add this test, there's no way to know.
I don't know what information the jury has been presented in this case. I was not privy to any of that information. They would just need to use the information that they're given to determine whether they felt like there was impairment.
Well, let me rephrase that. You would have to have that information, some additional information to go with this report. Otherwise, the number is meaningless.
Yeah, I think that the totality of the information of the case would be important.
Okay. So this report in and of itself doesn't really bring any helpful evidence from a point of determining cause of crash or if someone's impaired. This report will not tell us anything.
I'm not sure it's my role necessarily to check any boxes but just to provide the information that I have available.
Okay. Once again, a number in and of itself of THC cannot establish impairment of a person, correct?
That's correct. There is no correlation between the number that we find, the quantitation that we find in a person's blood with their impairment. That's correct.
No further questions.
I'm gonna redirect.
Is that the NHTSA Human Performance Fact Sheet?
It is not.
That's not the NHTSA report you have?
Agent, are you familiar with NHTSA's human performance fact sheets on different substances?
Yes, I am.
And does what that report from NHTSA says pretty much agree with everything you said here so far? As far as-
Yes, I believe so. That's one of the references that we use in training new scientists to help them understand the effects of drugs on the human body.
And if I were to show you page 10 on drug interactions under the marijuana section, would you be able to sort of look at that and tell us and refresh your recollection and say it says the same thing you said?
Yes, I believe so.
Mr. Moyer, we're probably going to let Mr. Arnold approach the witness so he can try to hand him the phone. Every time I try to hand someone a phone or they hand me one, I exit out of whatever's on the screen accidentally. So
Agent Quinn, do you have and or need reading glasses?
I do not
Oh,
currently.
well, fantastic. That second to last paragraph is drug interactions. Feel free to expand it. I believe the last sentence relates to alcohol in that paragraph.
what specifically is she looking at for our information?
The National Highway Transportation Safety Administration Human Performance Fact Sheet on marijuana and drug interactions with alcohol.
Is this the same document that Mr. Baker was asking about?
Unfortunately, it wasn't. I was hoping he had the same document so I could just hand her a much fuller sized.
Would you like me to read this sentence?
Please.
It says, when taken concurrently with alcohol, marijuana is more likely to be traffic safety risk factor than when consumed alone.
Those are my questions.
Recross?
Judge, may I have a moment? If you look at that third paragraph, now this is a 2017 study. What Mr. Arnold just showed you, I believe, was 2014. Is that correct? If you'll read that third paragraph to me.
It says a final judgment was made for the presence of alcohol. When both demographic variables and the presence of alcohol were taken into account, the odds ratio for THC declined further to 1.00, the 95% confidence limit of 0.083 to 1.22. This means that there was no increased risk of crash involvement found over alcohol drug abuse drivers.
All right.
May I scroll back
Yeah,
just to see?
go right ahead.
So it appears that this is speaking about the Virginia Beach study. which is a study that I'm familiar with, where drivers who had been in an accident received blood and drug testing, alcohol and drug testing after the accident. And then they made an effort to collect what they're calling control drivers. So people driving during the same days of the week at the same time and maybe under the same conditions if it was raining, to see if those people who didn't get in an accident, if they also had drugs in their system. This study did have some, it's just harder to characterize the effect that marijuana can have on a driver. And this particular study was not able to elucidate that there was an additional risk of having alcohol and marijuana on board. That does disagree with a number of other studies that I've read. And in general, I would say that it probably disagrees with the opinion of the community in general. But it is something that's very difficult to study. And different studies sometimes have conflicting answers.
Well, what I'm trying to say, are you going to say this study's wrong, this report of the National Highway Transportation Safety Administration, and this report to Congress is all wrong, but you're right? Is that what you're telling me?
What I would say is that science can be complicated, and we are tasked with not just looking at one single study, but at multiple studies over many years, and looking at the designs of those studies. And each study tries to do a better job, and we just try to provide the best information that we
To advocate for your point of view, correct?
can. No, sir.
May I have my report back, please? No further questions.
Redirect?
No, Judge.
Thank you, Agent. You may step down and we'll release you from your subpoena so you can go about your business. Mr. Arnold, you have any other witnesses?
Your Honor, that's the state's proof.
Ladies and gentlemen, if you'll step across the hallway, I've got to attend to a couple of administrative matters and then we'll come back.
All right, let's see here.
You may not need them, but
All right, you guys, hold on. Okay, so we are caught up. So this is day 3. Hold on. That's so funny. They're on break right now. That's okay because we don't have to wait around.
And so how long, do you recall the night of the accident?
Yes, sir.
And where do you work?
House of Brews.
House of Brews
Yes,
there in
sir.
Dixon?
Yes, sir.
Okay, and so if you will, just let me know or let the jury know what was going on at the House of Brews on October 3rd, just in generally what was happening there.
We were doing our annual October Street Fest,
Mm-hmm.
where we serve German food and beer, and we have a live band stand, and several bands that play that night.
Okay. And were you working this night?
Yes, sir.
Okay, so what was your role as far as what were you doing there?
I was outside doing hot dogs and brats, being kitchen manager. I also was back and forth upstairs and downstairs.
ma'am, I'm going to ask you if you will reach up there and grab the base of that microphone and pull it towards you just a little bit, it'll slide. There you go. Thank you.
Sorry, sir.
Judge. I was about to ask you to do that myself. Okay. So you were working and were you serving some beers? or-
No, sir.
Okay.
I was serving the food.
You were serving the food?
Yes, sir.
Okay. Did you see, the best you can, tell me about what time, the first time, did you see Jason and Haley there together?
Yes, sir.
Okay, round about what time was the first time you saw them?
Between 4:30 and 5 o'clock.
Okay. Now, is that down close to Xander's Pizza?
1 block away. Yes, sir.
Okay. So what direction were they approaching from?
They would have been coming from the north, heading south down Main Street.
Okay, so would that be from Xander's down towards the House of Brews?
Yes, sir.
Okay. All right. And did you interact with them
Yes, sir.
at around, what was that, 4:15, 4:30? So,
4:30, 5 o'clock, something like that. Yes, sir.
okay. How did they present themselves?
They were happy to see me.
Mhm.
And they wanted to give me love and let me know that they were there.
Okay. And were there a lot of people there that night?
Yes, sir.
Okay. Were there a lot of people drinking?
Oh, yes, sir.
I'm sorry about clearing my throat. I've got a bug. Did you see them multiple times
Yes, sir.
throughout the evening?
Yes, sir.
Okay. Did you have a chance to observe Mr. Brown throughout the night, his behavior?
Yes, sir.
Okay. And what can you tell me about that?
He was getting very intoxicated.
Okay. And when you say he was very intoxicated, how many intoxicated people have you seen in your life?
Many,
Okay.
many.
Okay. All right. And do you drink?
No, sir.
Okay. Occasionally?
Well, once a year, I might have a glass of wine or a half a beer with my daughter wherever she's stationed and I go visit.
Okay. She's stationed, is she military?
Yes, sir. She's Army.
Okay. All right. Have you ever been convicted of a crime?
No, sir.
Okay. All right. And do you recall around the last time that you saw Jason?
Yes, sir. It was about 7:45 p.m.
Okay. It's about 7:45 a.m.?
Yes, sir.
I mean PM. I'm sorry.
PM,
You
yes,
said PM?
sir.
Okay. All right. And tell me, was Haley with him?
Yes, sir.
Okay. Tell me about that interaction.
They wanted to come and give lovings and say goodnight, and that they were going home.
Mhm.
I asked Jason, was he driving? And because I wanted his keys if he was. And he said no, that Haley was good. She was driving them. I gave them both love, and he gave my sister love, and Haley and I stood close together at that point, and then they left.
Okay. Now you said you wanted his keys. What made you want his keys?
I've taken keys away from many people
Mm-hmm.
when they're drunk and too drunk to drive, and I wouldn't have let him drove if he was driving. I'd take his keys.
Okay. And when she was there, was she were you all in close proximity?
Yes, sir.
Okay. And did you feel like was Haley stumbling?
No, sir.
Was she distraught?
No, sir.
Did she have bloodshot eyes?
No, sir.
Did she have watery eyes?
No, sir.
Was she crying?
No, sir.
Okay. And what happened after that? Did Jason do anything else? What were you doing at this time, around this time? Was it?
We were getting the equipment and the tables and chairs moved back into the buildings, and then our customers and so forth would go back inside and finish the evening out.
Okay, so was there like a street fest that was it kind of shutting down at that point
Yes, sir.
and moving to the inside?
Yes, sir.
Okay. And that's when you interacted with them?
Yes, sir.
Okay. Are you okay?
Yes, sir, I am.
What'd you do to your arm?
I was in a accident and had to have a rotator cuff replacement, and then I broke my shoulder blade.
The vehicle accident?
No, it was like an ATV accident. My own silliness.
Your own silliness?
Yes, sir. I wanted to show my kids that I was still young and I could have fun.
You wanted them to, what were you doing to show them that you were still young?
Riding a racing little like dirt bike or whatever they're called. I call them ATVs. Everything's an ATV to me.
Okay. Did it get out from under you?
Yes, sir, it did.
Okay. Well, tell me a little bit more about that. What happened?
Well, evidently I hit a rock coming out of the driveway, and with short arms, the wheel turned real quick on me, And I panicked. I was trying to reach the brake, which I couldn't reach. And in the process, I was what we call whiskey throttling, pulling down the accelerator, making it go faster. I was panicked and didn't even realize what I was doing.
When you say whiskey throttling now, were you drinking whiskey?
Oh, no, sir.
Okay, so you were reaching back, you grabbing that
Yes, sir.
throttle because you couldn't.
I was reaching for the brake, and as I was pulling back on the throttle and going faster. And
And I don't want to talk about your arms. I can't even ride a bike, so I didn't mean to. Okay, so about what time would you say was the end of your encounter with Miss Brown and Mr. Brown?
7:45, 7:50, right in there.
And I don't know, I may have asked you this already. I'm sorry, it's been a long week. Did you ever see Miss Brown with a drink?
No, sir.
Okay. But it's possible that she was drinking something, right?
I didn't have eyes on her at all times, her or Jason, either one.
Okay. Did you see Jason with drinks?
Yes,
Okay. All right. And were you concerned about whether or not he was going to drive?
oh, yes, sir.
Okay. I have a moment, Your Honor.
Right.
Um, Did you interview with Major Christian and Mr. Summerhour sometime at the House of Brews?
Yes, sir, I did.
Okay. And you give them their account,
Yes, sir.
the account of what you saw that night?
Yes, sir.
And did you observe anything that would lead you to think that Haley Brown was impaired to drive or intoxicated?
No, sir, not at all.
Okay. And did you observe anything that concerned you about whether or not she could drive?
No, sir. She was fine.
Okay,
In my opinion, she was fine.
okay. And this was about 7:45 PM?
Yes, sir.
Were you gonna take those keys if you had to?
Oh, yes, sir.
Okay,
In a heartbeat. I've done it many a times.
okay. Thank you, Ms. Connor. Mr. Arnold may have some questions for you.
Mr. Arnold, you have any questions?
Just a couple, Judge.
Before I start, Ms. Connor,
Yes, sir.
we know each other, don't we?
Yes, sir, we do.
I've known you for probably about 10 years from when you worked at Hole in the Wall in Waverly. Is that fair?
Yes, sir.
And we're actually personal friends. Would that be fair?
Yes, sir, we are.
I just didn't want to not say that. And, is it okay if I call you Sue?
Yes.
Okay, thanks. I actually, until just now, didn't know that your real name was Melinda.
I'm usually in the doghouse when I get called Melinda.
Fair. So I kind of want to touch on one thing. You say it was about 7:45, you think, when they left? Is that right?
Yes, sir.
Now, when they left at 7:45, was Haley drinking anything?
No, sir.
And if she was leaving, to your knowledge, would there be any way or reason she could have drunk anything after 7:45?
No, sir. They got nothing from us.
Okay. And that's because y'all were taken outside down at that point, weren't you?
Yes, sir.
Now, I know you've told us what you remember, but would it also be fair to say that Oktoberfest at that time for House of Brews is a pretty big deal?
Yes, sir, it is.
And it required you to go not only outside, but also all over on the inside of the restaurant.
Yes, sir.
Got an idea? I mean, I know you said a lot. Any idea how many people were there?
No, sir. The street was packed, the bar was packed. There wasn't even hardly standing room in the House of Brews.
And not to be upsetting in any way or whatever, but in a crowd of people, you can't necessarily see everywhere in the crowd, can you?
That's very true. No, sir, you can't.
But I mean, you know,
Well, and I'm short too, so that puts me at a disadvantage.
yeah, I didn't want to ask it that way, but, and then I guess the last thing would be, and I know you said you had a lot of experience with, I mean, obviously, I've known you as someone who worked in a restaurant, and you're still working in a restaurant 10 years later.
Yes, sir.
Would it be fair to say sometimes that if two people are drinking together and one of them's a lot drunker than the other, the person who's less drunk might seem less drunk than they are? Is that fair?
I guess. Yes, sir.
I mean, if I see one person, no kidding, has to be supported, is falling down, and the other person isn't in that state, might I make a mistake about how drunk the better person is?
I mean, anything's a possibility, but I was face to face, cheek to cheek with Haley. We were talking in very close proximity. I smelled nothing on her breath. Her eyes weren't weird, and she was not stumbling when she walked.
So would it be very surprising to you to find out that 3 hours after you saw her, her BAC was twice the legal limit?
Yes, that would be very surprising.
Thank you. I don't know if Mr. Spratt will have some follow-up.
And Miss Sue, can I call you Miss Sue?
Yes, you can.
Okay, I get in trouble for that the other day. Why would it be surprising to you that her blood alcohol was that high?
She showed me no signs, no symptoms, none of that to be intoxicated at that rate or that point.
And you say you were face to face, cheek to cheek with her? Was she confused about anything?
No, sir.
Okay, so did she know who you were?
Oh, yes, sir. Mama Sue.
Okay. And again, so did her motor skill, do you know what motor skills are?
Yes, sir, I do.
Okay. Does that play into whiskey throttling?
That's part of it.
Okay. But you know what motor skills are?
Yes.
Right? Okay. So she didn't seem to have any problem with her motor skills.
No.
Okay. And you, General Arnold asked you, if you viewed somebody that was way drunker than the other person, would that skew your reality? That's fair that sometimes that might happen, isn't it?
Yes, sir.
Okay, but you specifically knew Jason and Haley, right?
Yes, sir.
Okay. So do you have any doubt whatsoever that she was okay to drive when you talked to her at 7:45 PM?
No doubt at all, or I'd have had them keys.
Okay, thank you.
You're welcome.
Arnold, any other further cross?
Just one.
But to be totally fair, you didn't administer a blood or breath test to anybody there.
No, sir.
And your experience doesn't include comparing how people look and act to specific blood concentrations, does it?
No, sir, it does not.
That's all.
Just briefly, is the first time you've ever been asked to do that, was that by General Arnold just a minute ago?
Yes, sir.
Okay, thank you.
Anything else?
No, Judge.
Thank you, ma'am. You may step down and you are released from your subpoena. Mr. Spratt, you may call your next witness.
We have a brief recess.
Ladies and gentlemen, we'll take a short recess. If you'll step across the way, please.
And have you watched the videos that have been played at this trial? Brown,
Good morning.
could you state your name and spell it for the court reporter, please?
My name is Haley Brown, HAILYBROWN.
And Ms. Brown, um, how did you know Jason Brown?
It was the love of my life.
Were you engaged to be married to him?
Yes, sir.
And how long were you guys together?
1,334 days.
Okay. Have you, when did you, do you calculate that number daily?
I have. Yes, sir.
I'm going to take you through some things here. Have you been able to see and observe everything that's gone on during this trial?
Yes, sir.
Okay. And have you watched the videos that have been played at this trial?
Yes, sir.
And do you recall interviewing with Major Christian and Sergeant Summerhour?
Yes, sir.
Okay. Now, I'm gonna start with I'm gonna start on October 3rd.
Yes, sir.
Okay. You recall what happened on October 3rd?
Yes, sir.
Okay. All right. How did your day start off?
As normal. Woke up around 6:30 in the morning. I knew that I needed to go see my grandmother. She was on hospice. My sister had not been with her, so we had made plans to go see her that morning. We decided to stop at McDonald's that morning. It was around 9:30 to get breakfast for ourselves and everyone at the house. We stayed there as long as we could. And then I believe I came home around 1:30. Jason was home. He was cleaning and rearranging the shed that day. We had a lot of trash to take off just because of that rearrangement. We decided to ride together to take the trash off.
Was that in your car?
That was in his truck.
Okay.
Yes,
Sorry.
yeah.
Okay. And then what?
We decided, it was actually his idea, surprisingly, to have a date night,
Okay.
to go to Dixon. We knew about Oktoberfest. And we made plans and went up there. But first, we went to Xander's
Okay.
to have dinner, an early dinner.
Okay.
That was around 4 o'clock.
Okay. And what all did you eat?
We had an appetizer, consisted of like cheesy bread
Mhm,
and I had a salad.
mhm.
And then we both had personal pizzas.
Personal pizzas.
Mhm.
Did you drink a beer while you were there?
Yes, sir, I did.
Had you drank anything prior to coming up there?
No, sir.
Who drove to Dixon?
Jason did.
Was that in your car?
Yes, sir.
Was that the Ford Focus that we've seen there?
Yeah, yes, sir.
Okay. All right. And so was everything going okay at dinner and everything? Did y'all have a nice time?
Yeah, yes, yes, sir.
Okay. And so what did you do after that?
We walked from Xander's down to Oktoberfest or House of Brews.
Okay. Did you hang out inside and outside a little bit?
I was more outside. The live music was outside. A majority of the people were outside. It was a really nice day, so we hung out outside a majority, but I did go inside sometimes. Yes, sir.
Did you have some drinks over the course of the time you were there?
Yes, sir.
Okay. At the time this happened, and I believe Major Christian asked you, did you hold a bartender's license
Yes,
at that
sir.
time?
Yes, sir.
Okay. And so take me through what you recall about the evening after you left Zangers while you were at the House of Brews in the Oktoberfest? What do you recall about that? Who did you interact with?
Oh, okay.
Sorry.
No, you're good. Mama Sue.
Okay.
We saw her. We knew that she would be there.
Mhm.
We specifically looked for her.
Mhm.
Found her, hugs and love, as she says.
Mhm.
And we were listening, to the music and looking for other people to see if we knew. There was a lot of people there looking to see if we saw other people. I noticed Katie Jo. She was there.
Okay.
And she had done my stepsister's makeup for her wedding that day.
Okay.
And so I approached her, and she was a few grades younger than me, so I knew about her. We knew about each other. So I asked her about the makeup, told her it looked really good, just huge compliments.
Your sister's makeup?
Oh, no, Katie Jo. Yes, my stepsister's makeup. Yes, sir.
Okay,
Yes,
alright.
yeah. The makeup looked really good.
Mhm.
And then I also saw Haley Weaver there.
Mhm.
Talked to her. And then as I was talking to Katie Jo, Haley approached us both. Didn't know you knew each other, and
Mhm.
we we did have that conversation all together.
Okay. And the whole time that you were there, were you and Jason together all the time, or was he drinking while you were there?
Yes, sir, he was.
Okay.
We were together a majority of the time besides going to the bathroom.
Okay.
Mhm.
All right. And at some point, did his behavior change?
Yes, sir.
Okay. Tell me about that.
Jason is a very reserved type of person. He's to himself,
Mhm.
typically.
Mhm.
And when he has alcohol or when he drinks, he becomes very loud and very loose as far as his body goes. He was hugging and leaning and just getting very touchy and feely with me, talking to other people, which he normally wouldn't.
Okay. Did he talk to anybody that made you jealous that night or anything?
No, sir.
Okay. I wanted to make sure where you were
Yeah, no,
going
sir.
with that. Okay.
No.
So go ahead. I'm sorry. Go ahead.
Hanging on Mama Sue as
Uh-huh.
far as,
Okay.
because he was gonna fall. He was stumbling. Yeah.
Okay.
Yeah.
All right. Now, going back to Katie Jo, she's the one that did your sister's makeup?
Yes,
Is that
sir.
right?
Yes,
Okay.
sir.
All right. At some point, did you take a selfie with Katie Jo?
Yes, sir.
Okay. Around what time was that?
7:28.
7:28 PM?
Yes, sir.
Okay. And you watched your interview with Major Christian and Sergeant Summerhour, right?
Yes, sir.
Did you mention that picture to them?
Yes, sir.
Okay. All right. Now, do you recall hearing Major Christian encourage you to have some sort of counseling after this all happened?
Yes, sir.
Had you already done that?
Yes, sir. The Thursday after.
Were you on any kind of antidepressants, mood things after this occurred?
Yes, sir.
Okay. All right. Did you attend grief counseling?
Yes, sir.
And as part of that grief counseling, were you trying to work on memories of this?
Yes, sir.
Okay. All right. And so, and I didn't mean to jump around on you, but so you taken this selfie and then what happened?
I took the selfie and I sent it to Katie Jo. That's how I got her number. She's like, send that to me. And I'm like, yeah, of course.
Uh-huh.
And so I get her number and I'm working on sending it to her. And as most people do, you look at yourself in that photo. You're like, do I want to send this to this person? Like, do I look good? And everyone does it. They check out the photo.
Well, is it difficult to call it a selfie when there's more than one person in it?
Yes,
always,
yes,
okay.
sir. I think we call it selfie because you do use the self front camera.
Okay.
Yeah.
So, all right, so you were looking at it, were you looking at, you sent it to her?
Yes, sir.
Okay.
Yes.
And what time did you send it to her?
Within the minute.
Okay,
Yeah, I've taken the photo. You know, we were looking at it and she's like, then send that to me. And shortly after that, within a few minutes.
did, as part of your grief counseling, did you go back and try to make a timeline to refresh your memory as to what was going on?
Yes, sir.
Okay. And have you been able to completely recover everything?
Not completely. There's about a 15-minute
Okay.
time block there.
At some point, when you and Katie Jo were looking at this, or were you looking at it by yourself later on your
Yes,
phone?
after I had sent it to her, I was zooming in on it because someone was in the background. Jason had tried to photobomb the picture. And someone was in that background and I was zooming in because he looked familiar
Mhm.
and I didn't know who it was. So I was zooming in on that specific man.
Mhm. Okay. Did you ever figure out who he was?
Later, yes, sir.
Later, as in, when you say later, was that after you had interviewed with them?
Way later after that. Yes,
Okay.
sir. Yes, sir.
So you've, all right, and who was it?
His name is Sam Moore.
Okay.
I know that just from Facebook. I have Haley Weaver on Facebook and they have mutual friends and I saw him in a photo and that's how I figured that out.
Okay. And at some point, did Jason see you zooming in on this?
Yes,
And
sir.
All right. And what happened?
He became jealous,
Mhm. Okay.
asking me, who is that? Why are you zooming in on that person? Do you know them? Who is that?
Mhm.
And I'm like, I don't know. I didn't know who it was.
At the time, that night?
At the
you didn't-
time, yes, sir.
Okay.
I did not know who it was. He did look familiar. That's why I was zooming in on him and trying to figure out who that was.
Okay.
But he was very concerned that I was zooming in on that man.
And was he agitated?
Yes, sir.
And so when did you say the picture was taken again?
7:28.
Okay. And at that point, what do you recall next?
Him getting agitated, me trying to change the subject, closing my phone out, accidentally taking a screenshot, trying to avoid that
Okay,
conversation.
let me stop you there. Have you characterized that as an accidental screenshot before?
Yes,
Okay.
sir.
And did you mention that accidental screenshot during your interview with Major Christian?
Yes, sir. I believe I did.
At that time, did you know why it had been taken? The accidental
Other
screenshot?
than it was an accident. No,
Okay.
sir.
All right, and I'm sorry to interrupt you. I just wanted to clarify.
Yeah.
So go ahead. What's the next thing you remember?
Just being on the sidewalk, everything's starting to shut down.
Mm-hmm.
Seeing Mama Sue,
Mm-hmm.
getting ready to leave. Other
Mhm.
people were going to like House of Vines. We decided not to do that.
Mm-hmm.
But just getting ready to leave. And
Okay.
That's it.
Do you remember getting in the vehicle?
Sir.
You don't remember that?
No, sir.
Okay, so you remember seeing Mama Sue,
Mm-hmm.
and you remember there, are you a private person?
Yes, sir.
Okay. Does it upset you to more or less discuss or have altercations or anything like that in public?
Yes, sir.
Okay. All right, so you remember seeing Mama Sue, and then what's the next thing you remember?
I remember hitting something, hearing that.
Mm-hmm.
I remember seeing Jason beside me, slumped over,
Mm-hmm.
trying to wake him up,
Mm-hmm.
and someone beating on my window, trying to get my attention so I wouldn't look at him.
Mm-hmm.
And I just remember trying to wake him up. Baby, please wake up. Please wake up. He wouldn't wake up. And then them getting me out of the car, trying to figure out, what my name is.
Were you saying they were trying to
The
figure it-
women, yes, sir.
Oh.
The women that were there. Initially one and then another one. Telling me that I flipped my car.
Mhm.
And
Did you know at that time whether you had flipped it or not?
No, sir.
Okay.
Just being on the scene of the accident. is What I remember next.
Do you remember sitting in the grass?
Yes, sir.
Okay, what do you remember about that?
Just being so upset. Pulling at the grass.
Mhm.
Screaming, crying.
What were you worried about anything?
Jason?
Okay. And this is when you were in the grass?
Yes, sir.
Okay, all right, go ahead.
I just remember the women being in my face, trying to figure out who I am, if I'm okay,
Mm-hmm.
and just being concerned about Jason.
Mm-hmm.
I contacted my mom, and then I remember wanting my mom, my sisters, just family, someone to console me.
Mm-hmm.
Just multiple people there, police officers, fire, EMS.
Were there a lot of people talking to you?
Yes, sir.
Okay,
Yes, sir.
all right. What do you recall about that?
Just as far as just,
Well, did you know how many people were talking to you and asking you questions and what was going on?
there was multiple people,
Okay,
and so also I was on my phone.
okay.
So yes,
Alright.
multiple people.
Did you repeat anything back that anybody said to you?
Yes, my stepdad Randy was asking me, Haley, where are you at? I'm like, where am I at? I'm in, you're in Dixon. I'm in Dixon.
Okay. So you were talking to, and is Randy Brassfield, is that correct?
Yes, sir.
Okay, and then that's Mr. Brassfield back here. Is your-
Yes, sir.
All right, and so you were on the phone with him?
Yes, sir.
So, and you saw the video, right?
Yes, sir.
Okay, so you were repeating things that other people were saying to you?
Yes,
Is
sir.
that what you're saying?
Yes, sir.
Okay, so go ahead with that. What's the next thing you remember?
I just remember asking if am I going to the hospital? Because I was asked that, am I going to the hospital? Yes, you're going to the hospital. Likely you're going to the hospital. Which hospital? Horizon. And then, just asking me multiple questions, the police officer did.
Mhm.
People asking me if I'm okay, trying to get me in the ambulance. Checking me out as far as injuries and things like that go. Yeah.
Do you recall being in one ambulance and then going to another ambulance?
Yes, sir.
Now, do you recall that? Do you recall that from memory or from what you've seen up here? Or both?
Both.
Okay.
Yeah.
All right. Do you recall somebody in that ambulance telling you something?
Yes, sir.
What did they tell you?
that Jason was dead.
And how did that make you feel? At the time?
Yeah,
At the time.
Just awful, just so broken and awful, and just it's very indescribable, but just awful.
And I mean, the effect on you.
And also, I felt, sorry, just
No, you go ahead.
suicidal. I didn't want to be there anymore.
Okay.
I
So-
wanted his life traded for mine.
And did you say that night?
Yes, sir. Multiple times.
Okay. Did you say that? Did you start saying that after you were told that? That he was deceased? Is that when you started saying that?
Yes, sir.
Okay. Now, at some point, you became suicidal. Were you on the phone still when you were in the ambulance?
Yes, multiple times I was on the phone. Yes,
Okay,
sir.
all right. And at some point, you became confused, right?
Yes, sir.
Okay. Tell me about your relationship with your natural father.
It's not the best
Okay.
up until now.
Mm-hmm.
He has been in and out of my life. He's been to jail multiple times.
Mm-hmm. Was
Just-
there a specific event early on in your life?
Yes, sir. He tried to kill himself.
Okay.
He tried to commit suicide.
Okay.
And I remember being there for that. Going to the hospital, seeing him on a ventilator, them pumping his stomach. It's probably the most, before this accident, the most traumatic thing that I've been through.
And do you believe that this had something to do with why you were confused and confusing these things?
Yes, sir, absolutely.
And what did you want more than anything while you were in that emergency room?
For Jason to be alive and for them to trade my life for his.
And if you couldn't do that, were you wanting somebody else?
Yes, my mother or my sister, mainly my mom.
Okay. Now, you refused some medical treatment. Was there a reason that you were doing that?
Yes, sir. I didn't have health insurance at the time. And I know how costly it is, healthcare is,
Okay.
and that was why I was refusing it. I didn't have the money.
Did you feel physically injured?
No, no,
Okay.
sir.
And you weren't physically injured, were
Right.
you? All right. Now, do you recall Sergeant Summerhour coming in to ask for the blood?
Yes, sir.
Okay. And at the point when that happened, had your mom entered the room right before that?
Yes, sir.
Did you calm down immediately?
Yes, sir.
Now, and I've asked you about this grief counseling. Is part of that, is that where you were trying to recover memories? Is that
Yes, sir.
fair? Okay. And to this day, can you remember what happened in the car with you and Jason?
No, sir.
Okay. Now I want to ask you a couple of things. How many speeding tickets have you had?
say 3 to 4.
Okay.
Mhm.
Around that time?
Yes, sir. Yeah.
Okay. And did you ever, any of those times that you pulled over, were you ever drinking?
No, sir.
Okay. So would you describe yourself as having a lead foot?
Yes, sir.
Now, did you listen to and I've asked you this question again, but when I'm jumping back and forth, I'm going to refer to what I'm going to ask you about.
Yes, sir.
The interview that you gave with Major Christian and Sergeant Summerhour. Do you believe that your speed was a factor in this wreck?
Yes, sir.
Do you believe that the speed ultimately caused the wreck?
Yes, sir.
Okay. Do you believe that your ingestion of alcohol whatsoever caused that wreck?
No, sir.
And do you recall Major Christian saying he was going to try to interview witnesses
Yes, sir.
to support what you just said, right?
Yes, sir.
Okay. He was more than fair with you, wasn't he?
Yes, sir. Absolutely.
All right. And do you recall that he doesn't know what caused the speed? Do you recall him saying that?
Yes, sir.
Okay. And do you recall him saying that you had been upfront and honest?
Yes, sir.
Okay. Now, you did not recall during that interview the selfie and Jason becoming upset about the selfie.
Yes, sir.
Okay. But you did recall the selfie itself. Is that fair?
Yes, sir.
Okay. And did you zoom in and look at this? How many times have you played this out in your mind?
Hundreds.
And how many days did you say this had been that you've known Jason?
1,334.
Have you ever told me that before today? Have you driven back through the route?
Yes, sir.
Okay. Were you familiar with Walnut Street before you went down Walnut Street?
No, sir.
And you have driven back down through the route?
Yes, sir.
Is there a speed limit sign between where you told Major Christian you were parked and where the wreck happened?
No, sir.
Have a moment, Your Honor.
You may.
Ms. Brown, did you hear Agent Bramlage testify as to what your blood alcohol was?
Yes, sir.
Do you believe that was possible?
No, sir.
Were you intoxicated that night?
No, sir.
And you don't remember what happened in the car?
No, sir.
Thank you, Ms. Brown. I'll pass the witness, Your Honor.
Arnold, you may cross-examine.
Morning, Ms. Brown.
Good morning.
Now, you talked about this selfie at 7:28.
Yes, sir.
Okay. And you heard Ms. Sue testify that they closed down the Oktoberfest round about 7:45, and that's whenever you guys left to walk to the car.
Yes, sir.
And maybe I'm putting words in your mouth, but you remember from 7:28 to leaving the sidewalk pretty good, don't you?
Yes, sir.
So let me ask you something. Did you drink anything from 7:28 PM to when you and Jason left House of Brews?
Not to my memory.
So from the selfie to things closing down and y'all leaving, you did not have a drink.
Object, Your Honor. I think she said she can't remember. I think that was asked.
Cross-examination, overruled.
So no, sir. It was your answer, I believe.
Not to my knowledge.
Now, you remember the interview with the officers, right?
Yes, sir.
Okay. Do you remember finding 2 purchases for alcohol from House of Brews, one for 27 something, one for 29?
I did
something?
not say alcohol. I had 2 charges on my credit card.
Okay. But you're not sure what those are for?
No, sir.
But you did tell them you had a shot of Crown,
Yes, sir, I did.
at least one that you
I
remember.
told them that. Yes, sir.
And you did have one of those brews. one of those
At
brews.
Sanders.
But do you remember telling them that you at least bought another one at House of Brews?
And handed it to Jason. Yes, sir.
Do you also remember telling them that usually if you were going to drink either beer or whiskey, it's going to be one or the other?
Yes, sir, I remember that.
Okay. So given that you passed off a beer and drank a whiskey, would it be fair to say this would have been a whiskey night?
This was a date night. This is not a whiskey night. No, sir.
Okay, but you had a whiskey
I did.
and you decided not to have beer.
Yes, sir.
And you normally do one or the other, but not both.
Yes, sir.
Okay. Sitting here now that you've done all this work on memory, have you been able to recover any more memory about the things that you drank before 7:28 that night at House of Brews?
No, sir.
Do you still remember at least a shot of whiskey and passing off a beer?
Yes, sir.
But still today, that's all you remember.
Yes, sir.
Now, you testified just now that you were basically uninjured physically that night. Is that fair?
Yes, sir.
Were you discharged that night from the hospital?
Yes, sir. And I returned the next day for a panic attack.
Okay. But in terms of the physical injuries from the hospital itself, ultimately, when they were able to establish how you're doing, they discharged you, didn't they?
Yes, sir, they did.
Now, when Mr. Spratt asked you if you had any further recollections about the cause of your speed, right, you just now said no. That you haven't had any additional recollections. Do you remember telling Mr. Spratt that just now?
I'm sorry, repeat that?
He asked you if you had any additional memories about what caused you to be driving so fast,
Oh, yes.
and you said that you don't.
Yes, sir.
Okay, but let me ask you, was anybody driving that car other than you?
No, sir.
And when you got those 3 or 4 speeding tickets, was anybody driving the car but you?
No, sir.
So would it be fair to say that your driving fast is probably the cause of the speed of the car?
Yes, yes, sir.
And so sitting here right now, it's your recollection that from 7:28 PM, you didn't have anything to drink,
Correct.
but you don't have any additional recollection about what you had to drink before 7:28 PM.
Not specifics.
So, and I know you already said that you didn't think you were drunk. I understand.
Yes.
But sitting here today, are you saying that you only had 1 shot at House of Brews and 1 beer at Xander's?
I'm saying that's what I remember.
So you're not saying that you couldn't have had more?
I'm saying that's what I remember.
Okay,
Yes, sir.
let me try it another way because I don't think I'm getting at it very good. You're not saying that you remember definitively that you didn't have more. You're just saying the only ones you remember are those. correct?
Correct.
So as far as your memory is concerned, you could have had more. You have no memory one way or the
I
other.
object. This has been asked and answered several times.
Overruled, cross-examination.
Can you repeat the question, please?
So you don't remember more than those, but that's not the same thing as saying you remember for sure you didn't have more than those. Do you understand the question?
Yes.
So today you're not saying, I, Haley Brown, remember that those are the only drinks I had. You're just saying, those are the only drinks I remember.
Yes,
Correct.
that's what I'm saying.
Okay. And if the science said something else, you wouldn't necessarily be in a position to dispute that then, would you?
I don't agree with the science.
That's fair. Those are my questions.
Redirect.
Ms. Brown, would you feel better about the science if you had a blood sample from about 30, 40 minutes after that wreck than you do about what you ended up with here?
Yes, sir.
Okay. And the, you don't recall everything about what happened, right? As far as from the time that selfie was taken until you left?
Yes, sir.
Okay. And, but is it your testimony that you think it was impossible that you were double the legal limit when you were driving this
Yes,
thing?
sir.
Okay. And what do you know caused the wreck? What can you say for sure caused that wreck?
Speed.
I'm sorry, Ms. Brown, I hate to do this. It's the same question as, one of the same questions asked Ms. Sue, okay? Have you ever participated in a study where you compare the amount you've drank to a known blood alcohol content?
No, sir.
Okay, so you've never participated in a study where you had, say, 2 drinks, and then they tested your blood and told you what the BAC was, and then you had 2 more and tested your blood and they told you what your BAC was?
No, sir.
So honestly, sitting here right now, you don't know how many drinks it would take to take you to the legal limit, do you? The legal limit I'm talking about,
Right.
not how
I've
you
never
feel.
been in a study like that. No, sir.
And so you wouldn't have any idea how many drinks it'd take to be double the legal limit.
I've never been in a study like that, so no, sir.
Okay. Thank you. That was it.
Mr. Spratt, anything else?
Maybe have a moment, Judge.
Ms. Brown, would you remember if you drank several gallons of beer in that 20 minutes?
Yes, sir.
Okay, do you believe you drank several gallons of beer in that 20 minutes period?
No, sir.
Those are my questions.
No follow-up, Judge.
Thank you, ma'am. You may step down and have a seat by your order. Mr. Spratt, you may call your next witness.
Your Honor, the defense, may I have just one moment? Your Honor?
All right.
Your Honor, the defense rests.
This is rested. State have any rebuttal proof?
No, Your Honor.
All right. You, ladies and gentlemen, we're going to go to closing arguments now, and then after closing arguments, I'll give you a break before I start reading you the 17 pages of instructions. But I want to give the lawyers their opportunity. Officer Howe, you want to make our adjustments to the podium?
Your Honor, may the state visit the little lawyer's room before he begins his closing argument?
I'm sorry, can the state what?
The state needs a restroom break, Judge.
You ever see the movie Paper Moon with Tatum O'Neal and Ryan O'Neal? He said, I believe you've got a bladder the size of a kidney or a peanut or something like that. There was a line in it, I remember that. Let's go ahead and take our restroom break, and then that way, after closing, I'll go directly into reading you this charge. We'll be in recess for 15 minutes.
Oh, wow.
Rise. Court's now in recess for 15 minutes.
This really picked up fast. I didn't know she was going to testify. Okay, my opinion.
Jason Brown.
Okay, I want to say this. Jason's life mattered, okay? No doubt. I don't think she did this intentional. She's going to be living with this nightmare the rest of her life. Okay, here we go, closing.
Was Haley Brown's passenger on October 3rd, 2020 at 8 p.m. when she exceeded the critical velocity of the curve on West Walnut Street, slide slipped into a yaw, and struck a light pole almost exactly where Jason Brown was seated. The tire in his side of the car. It slid along his side of the car as the car rotated around the pole. And in that event, Jason Brown's head struck the interior of that vehicle and he died virtually instantly. You have the testimony of Dr. William McLean from the ME's office that, as he called it, eggshell fracture to the brain would have been immediately fatal and was the cause of death of Jason Brown. So that's the first element. And I have to tell you, that element, I would submit, is proved beyond a reasonable doubt by the road evidence, by the testimony of Major Christian of the Dixon Police Department, by the testimony of the medical examiner. So the next thing that has to be proved is that Haley Brown's operation of that vehicle was reckless. We know from Major Christian's testimony that her operation of the vehicle was such that it exceeded the vehicle's ability to negotiate the curve. He gave us a figure of 56 to 58 miles an hour from measuring the chord and middle ordinate of the yaw in this case. And he explained that he downloaded the CDR data from the vehicle, and the vehicle's own recording of its speed supported this speed assessment within a couple percent tolerance. I submit to you that going 58 in the middle of the city of Dixon, where the speed limit is 30 and the road is completely surrounded by houses, is in fact reckless operation of a vehicle. Now I submit to you further, and this goes a little bit to the third element, so I hesitate to mention it, that getting behind the wheel of a car under the influence of alcohol and marijuana is also reckless. So I think that second element is doubly met by the facts in this case. And then the third element of vehicular homicide by intoxication is that Haley Brown was intoxicated at the time she was operating the vehicle, and that her intoxication was the proximate cause, the but-for cause of Jason Brown's death. You'll get an instruction explaining proximate result. What we'll tell you is that one thing is the proximate result of another if it wouldn't have happened if that earlier thing had not happened. So in terms of proximate result, what the state is required to prove is that but for Haley Brown striking that light pole, Jason Brown would be alive, and but for the fact that she was intoxicated, she wouldn't have struck that pole. That is the third element. And so let me talk a little bit more about that third element, because I think a lot of the argument here is going to be on intoxication. And that was the bulk of the state's proof yesterday, the bulk of our proof on the second day. Here's what the proof tells us. The proof tells us that almost exactly at 8 p.m., Haley Brown operates the vehicle in such a way that it strikes that pole and kills Jason Brown. That's 2000 hours. From 2000 hours to 2248, you heard from a series of witnesses and watched, admittedly, pieces of a tape that is a continuous tape, but we didn't play all of it because that would have been 3 hours of tape to play for you guys. But she was continuously in the custody of and control of private citizens, EMTs, and police officers who testified. And from 8 p.m., from 2000 to 2248, when her blood was drawn, she consumed no alcohol and she smoked no marijuana. We know that by our own eyes, by our officers' own eyes, by their testimony. We know that. In spite of that fact, her blood alcohol content at 2248 p.m., as determined by the Tennessee Bureau of Investigation expert toxicologist, 0.161 BAC. We heard April Bramlage testify that is twice the legal limit here in the state of Tennessee. Now, there was a lot of confusing conversation from the cross-examination about curves and whatnot. But I don't know if you guys paid attention to this. When I pointed out to Special Agent Bramlage that there was no consumption from 2000 to 2248, she was able to say a lot more about what it would be like at 2000. The first thing she said was, it would be higher then. Without knowing that information, that there was no consumption in that almost 3-hour period, right? She had to admit, could be higher, could be lower, could be the same. But once she had that additional piece of information, she said it would be higher then. Here's why she told us that. She gave us the reason. She said absorption, the first part of that curve that was shown in cross-examination, takes at most 30 minutes to 1 hour after consumption has ceased. If we know consumption has ceased at 2000 hours, right, then we know absorption is done at 2030 or at worst case scenario, 2100 hours. So we've got 2 hours of what's called elimination. That means at least 2 hours, 2.5 or 2 hours, depending, during which the blood alcohol content is decreasing. In spite of that, at the time of our measurement, we've got twice the legal limit, 0.161. She told us what we would expect if we went back 2 hours from that. 2 hours from that to the peak, she said, would be 0.181 to 0.201, depending on the individual. But that pretty much all human beings will be in that range. Here's the thing, though. You guys now have more information than you had when Special Agent April Bramlage testified about intoxication. What additional information do you have? The defense's own witnesses. Sue Connor tells us that she is sure that Miss Brown didn't have anything to drink from 7:45. So you can go back 15 more minutes. Now we have a full 3 hours of no consumption. And what did Special Agent Bramlage tell us would be a backwards extrapolation, assuming 3 hours of elimination? She said 0.191 to 0.221. But I don't know if you guys noticed, but I spoke to Miss Brown about some of her recovered memories. And she seemed pretty sure that from the time of the selfie, which she remembered very specifically at 7:28 p.m., to the time that her and Jason Lee Brown left that sidewalk at about 7:45, she doesn't know how much she had exactly. She doesn't know what she had exactly, or doesn't remember, right? But she's pretty sure from 7:28 on, she wasn't drinking. So that means the peak couldn't have been later than 8 or 8:30, because April Bramlage told us 30 minutes to an hour. That's a lot of math. The point is this. Her blood alcohol content at 8 o'clock when she struck that pole was definitely over 0.08 gram percent, 0.08 of a percent. Definitely. Actually much higher than that, but definitely that. Why does that matter? Because here in the state of Tennessee, the state can prove intoxication in one of two ways. The state can either prove that a person is under the influence of a substance that affects that person's central nervous system to such an extent that it impairs that person's ability to operate a vehicle safely. Or the state is allowed to prove it by showing that the person's blood alcohol content is 0.08 or higher. And my suggestion, and what I'm telling you is, even if you don't think Haley Brown's intoxication at 8 o'clock is such as to have impaired her central nervous system, if you believe her BAC is 0.08 or higher, here in the state of Tennessee, she is intoxicated by definition. Now, I would suggest that we have an abundance of evidence that her central nervous system was also impaired at 8 p.m. When I say we have an abundance of evidence of that, I really have to explain what I mean. Because our toxicologists are very good, they're very careful, they're smart people, okay? They have had a lot of training about what alcohol and drugs do to the human nervous system. But they're testifying in general terms, which means you have to, they can give you symptoms. Special Agent April Bramlage can give you the symptoms of alcohol intoxication, and she did. Special Agent Linda Quinn can give you the symptoms of marijuana intoxication, and she did. But then what you have to do, just like anything else, right? You know the symptoms of a cold. How do I know if I have a cold? What am I experiencing? You have to compare it to the evidence that you guys saw over the last 2 days. So what are the symptoms that we were given for alcohol intoxication? We were told lack of coordination, poor decision-making, impairment to memory, difficulty perceiving time and distance, impairment to cognition, learning, and memory. Interestingly enough, those descriptions of symptoms of intoxication apply to both alcohol and to marijuana. So now we ask ourselves, we watched all of this video of Miss Brown from 8 o'clock to almost 11 o'clock at night. Did she exhibit poor decision-making? Well, I don't know. It seems like she did, right? 58 miles an hour in a 30-mile-an-hour zone, to me, is poor decision-making. Losing the critical speed of my vehicle on a curve is poor decision-making. It suggests that I'm not perceiving time and distance correctly. What is time and distance? What is time over distance? It's velocity, it's speed. I don't know how fast I'm going. That is a sign of intoxication by alcohol, and it is a sign of intoxication by marijuana, both of which are found in her blood 2 hours and 48 minutes after she crashes that car. Impairments to cognition, learning, and memory. Ladies and gentlemen, over the course of 2 hours and 48 minutes, she forgot she had killed her boyfriend. And then she thought she might have killed her boyfriend and her father. I do not know how much more strongly we could have shown you the symptom of impairment to memory. In her interview with our officers on October 23rd, 3 weeks later, she still has significant memory gaps. Again, a symptom of intoxication by alcohol, a symptom of intoxication by marijuana. Now, that is also a symptom of some other things. It really is. But you guys heard testimony from Miss Brown herself that she was physically uninjured by the wreck. And I think you saw with your own eyes that outside of emotional distress and potentially signs of intoxication, she appears to be physically uninjured. So physical injuries are not the explanation for her loss of memory, for her inability to behave as she otherwise would behave. I would suggest to you that you can see those symptoms in an additional way. If you compare Miss Brown today or on October 23rd with Miss Brown in that video, surely Miss Brown is grieving the loss of Jason Brown on October 23rd, 2020, 3 weeks after she killed him in that wreck. Surely she's grieving him then. I suggest to you that the difference between her appearance in that interview and her appearance on that scene, that one of the main reasons for that difference is she is displaying the signs of intoxication. But you don't merely have to rely on me for that. Christy Parchment is on the scene moments after the wreck occurs, just behind Melissa Phillips, and Christy Parchment smells alcohol. Now, she doesn't know, she can't say for sure whether it's coming from Melissa Phillips or Haley Brown, but she smells it. And she tells the officers. And we know where the source of that smell comes from, because Haley Brown herself admits that she's been drinking, but she can't tell us how much. Officer Reprogel, who spent more time with Haley Brown than any other individual on the scene for 3 hours, closer and further away, at points in physical contact with Ms. Brown, testified that she was obviously intoxicated and that she had had occasion as a Dixon Police Department officer to encounter intoxicated people under many different circumstances, many different times. So I submit to you that evidence of intoxication is, in fact, scientifically proved beyond a reasonable doubt in this case. And so then I have to go to the defense proof, just briefly. Virtually every single thing, if not every single thing, that those two ladies said on the stand could be true. And it changes none of the facts that I just described for you. None of them. The state of Tennessee is not required to prove that Haley Brown believed she was intoxicated. That is not an element of this offense. If belief that I was too intoxicated to drive was an element of DUI, DUI would barely exist as a crime in the state of Tennessee or in the United States. Because by definition, if I've decided to get behind the wheel, more often than not, I think I'm okay. That can't be the standard, and it's not the standard. It's not something the state is required to prove. Absolutely not. What the state is required to prove is that she actually was intoxicated, as it's defined in the instructions you're about to receive and by the state of Tennessee. That is what we're required to prove beyond a reasonable doubt. Not that somebody thought that she was intoxicated, but that she actually was. And I'll tell you, the reason why one of the reasons why people do not believe that they are intoxicated and make the decision to drive the car is because of the very symptoms my toxicologists explained to you guys, right? The poor decision-making, the inability to perceive accurately. If it was enough that I was misperceiving things to get off the hook, right, then voluntary intoxication would be a defense to everything. You're going to get an instruction in your jury instructions that explains that voluntary intoxication doesn't excuse everything. I need you to pay attention to that as well. Remember, when I talk about these elements, you're going to get an instruction about the law that says absolute certainty of guilt is not demanded by the law to convict of any criminal charge, only moral certainty. And again, moral certainty as to what? As to the elements I'm required to prove, not as to any of this other information that you've heard. The state must prove beyond a reasonable doubt all the elements of the crime charged and that the crime occurred in Dixon County. That's it. The elements of the crime charged, not required to prove anything else. Finally, we heard testimony from a person I have no reason to disbelieve, okay? Miss Sue Connor, that Haley Brown seemed okay to her. Now, I think that's mitigated somewhat by the fact that Jason Brown is much drunker. And you have the ME's report. You can see his BAC. There's no card trick. There's no magic trick here. I don't dispute that. Jason Brown's intoxication at the time of his death is not an element that the state is required to prove. It's not a question that the instructions are asking you guys to answer. But when you read the jury instructions, when the judge reads you the jury instructions, you will discover something about intoxication in the state of Tennessee. The instructions say that it's not necessary that the person be in such a condition as would make her guilty of public drunkenness. That is not required. The person doesn't have to look drunk. Any condition that deprives one of the clearness of mind and control of oneself, which one would otherwise possess, or if the person has greater than 0.08, 0.08% alcohol concentration in his or her blood or breath, then that person is intoxicated in Tennessee. How bad does the impairment have to be? It has to be bad enough to impact your ability to safely operate a vehicle. If there is anything that was proved in this case, it is that Haley Brown did not have the ability to safely operate the vehicle. The reason why we all know that is because she very clearly did not safely operate it. She operated in such a way that it killed her passenger. So I know her degree of intoxication reached that level. Once again, beyond a reasonable doubt. That's the first count in the indictment. The second count in the indictment is vehicular homicide by reckless conduct. In order to prove that, the state has to prove that she operated a vehicle in such a way as that it killed someone. Once again, I don't think there's any question to that. She has to have been shown to have operated it recklessly. Again, 56, 58 miles an hour in such a way that exceeds her abilities of her vehicle to negotiate the curve, I think, is reckless. I know it's reckless. And by reckless, we mean in such a way as to create a serious risk that it will seriously injure or kill someone. Not only was there a serious risk that her driving of the vehicle would seriously injure or kill someone, it did kill somebody. So we've got that, right? And the recklessness of her operation of the vehicle has to be the thing that caused the death. And again, it's what we call but-for cause. If she hadn't operated the vehicle recklessly, Jason Brown wouldn't have died. That's what has to be proved. And I would submit to you that in addition to her speeding, getting on the road with those substances in her bloodstream is, by definition, a reckless act in the way that recklessness is defined in those instructions. So if you find her guilty of operating the vehicle while intoxicated, knowing that it caused Jason Brown's death, you virtually have to find her guilty of vehicular homicide by reckless conduct. And then finally, the last count in this indictment is simply the count of driving under the influence. Now, one thing that I found juries find confusing and a little bit like disconcerting and upsetting that I found that they've found in the past is when a single event, in this case, a single homicide, leads to 3 separate charges. So I want to touch on that just briefly. First off, the instructions are going to tell you that you're to consider each of the charges separately, one at a time, and go in order. So obviously you want to follow those instructions because that's the law. But if you were to convict her of all 3 of those things, they would merge together into one. It would actually be one conviction. If you were not to convict her of one, but convict her of another, say 2 of them, those 2 would merge. Does that make sense? It's been a long couple of days. I very much appreciate y'all's time and attention. And I know that when you consider the evidence that was presented about the elements themselves, the questions that you're being asked to answer, when you consider all the evidence that came from the stand, in particular, the scientific evidence, the crash reconstruction, the blood evidence, that you will be forced to find her guilty of the 3 counts in this indictment beyond a reasonable doubt. Thank you very much.
Mr. Spratt?
Just one moment, Your Honor.
Morning, ladies and gentlemen. Thank you for your time in listening to this case. We both said, General Arnold and I agree, that this is going to be a tough case to hear. These kind of things are always they're always difficult for everybody involved. So we appreciate your time and attention. A few things about what General Arnold just said. First of all, what he's asking you to do, what the state's asking you to do, is look at that .161 number and convict and be done, and we're out of here. Well, and then he gave Officer Bramlage during that testimony, he gave her a variable. Mr. Baker cross-examined her about what variables would be necessary in order to backwards extrapolate, retrograde extrapolate, whatever that was at the time that she was driving. One of those variables very well actually was that there was no drinking. But what he failed to ask her about, or what he failed to tell her about, was that Miss Brown had eaten. They didn't know anything about Miss Brown's experience or fill in any other of those variables. So Special Agent Bramlage, who he describes as his toxicologist, tells you on his facts that he wants to pluck and choose for you that, oh yeah, we can say that she was way over at the time of driving. This is nothing more than a math problem that they just want you to guess at. And you have evidence and you have exhibits, and when you go back there, you'll be able to review those exhibits. And I would like to direct you, if you can, it's at your disposal for when you deliberate. Look at the report. Look at the report that shows the .161. That report sitting by itself right below that .161, which is blown up in big font for you to look at because that's good stuff for everybody to look at. That's what the state wants you to look at. Right below it, right when it was taken, it says the above amount is the average of 2 tests plus or minus 0.008 grams percentage. That tells you right there that that number sitting there by itself could have been a 0.0153 or a 0.169. So this is not an accurate test. It tells you it's not accurate. It says 99.73% confidence level that it's 99.73% confident that it's potentially plus or minus 0.008 wrong. And it's given by a state paid toxicologist in order to make you bite on a number and convict somebody. But that's not the end all be all here. Whether you find that Ms. Brown was over that limit or not, for you to convict her of vehicular homicide by intoxication, the state has to prove beyond a reasonable doubt the 3 elements that General Arnold told you, and Judge Wolf will instruct you on those. They have to prove that the defendant killed the alleged victim, Jason Brown. And he's right, that's not in dispute. That's not in dispute. And nobody's asking you to make your decision based on sympathy or anything like that. You watch tapes, you've seen the evidence, and it's a tough case, as I've talked about. That the defendant acted recklessly. Well, she said she was unfamiliar with Walnut Street and that curve. She said she was speeding. She doesn't know why she was speeding. But one thing's probably not in dispute. Major Christian's testimony, that vehicle was speeding. But you heard from Ms. Brown, she speeds a fair amount. But what I want you to focus on, and what I'm asking you to focus on, is that the killing of Mr. Brown was the proximate result of the driver's intoxication. So separate the fact that there could be intoxication. You can find intoxication. What you have to find beyond all reasonable doubt, moral certainty, and Judge Wolf will instruct you as to moral certainty and reasonable doubt. And we talked about that in voir dire. Not only that she has to be intoxicated, but that intoxication caused the speed, the reckless conduct, and the death. Well, you heard from Dr. McLean, the medical examiner. Mr. Baker cross-examined him about that. And if you'll recall, Mr. Baker asked him specifically, could somebody have a 0.161 blood alcohol count and still not have lost motor function? And he said, yeah, it's possible. So if there's no loss of motor function, if that's possible, then what has the state put up to prove to you that the alcohol caused the speed? In fact, what the state put up was just the opposite of that. Now, Major Christian and Sergeant Summerhour, they were more than fair with Miss Brown in her interview. She cooperated. She came in, and he said, and you heard him say this, speed is a factor. I can't tell you what caused the speed. And that's the crux of this case. That is the absolute crux of this case. They cannot tell you exactly what the number was because they didn't have all the variables. And on cross-examination, they wanted to plug in the variables that supported their theory. But we cannot say, based on testimony, based on the science, that any level of intoxication caused the speed that caused the wreck, which caused the death. We know that Ms. Brown, we heard from Ms. Brown. She testified, and she has some memory loss. And Major Christian encouraged her to go to grief counseling, which she did. And she, for the first time today, could tell you exactly how many days she had known Jason Brown. And working through those issues and looking through some of those things that she was, and this is in Major Christian's words and Sergeant Summerhour's words, that she was upfront, honest, cooperative, and truthful with them. And she, in studying some of the things that she had mentioned to them, she recalled that there was an altercation, or that there was at least some friction between her and Jason that night. Now, she didn't get up here and try to tell you that some crazy event happened in the middle of the car. She didn't try to make anything like that up and try to convince any of you of that. If she was going to go all in and say some self-serving stuff like that, you probably would have heard her say that he jerked the steering wheel or something like that. She didn't come up here and tell you anything like that. She just told you what she remembered. Now, looking back at the proof of her scene, the proof of her demeanor, her appearance, her confusion on the scene. First of all, I'd like to go back and address Sergeant Chandler's, and not to harp on Sergeant Chandler, but this was chaotic. The whole scene was chaotic, even for Sergeant Chandler. So nobody's trying to insinuate that Sergeant Chandler actually intentionally made up what Miss Brown said to him when he first encountered her. But he was at best confused. So nobody's trying to insinuate that Sergeant Chandler was drinking or that he had lost it. He was confused. This was a highly tense situation. And that got translated from one officer talking to Miss Brown, and then talking to another officer, and to another officer, and to another officer. And before you got it, there's a completely false pretense for probable cause. Now, smelling the alcohol is enough to, that's fine, but it's an example of somebody being confused on the scene that we know wasn't drinking because of the intensity of this situation. So, as General Arnold mentioned, that Officer Reprogel did spend a more than fair amount of time with Haley that night. And she interacted with Haley for 5 minutes, from 8:16 p.m. until 8:21 p.m., at which time she was 10 feet away from Haley in the back of an ambulance. And she makes a determination that Haley is clearly intoxicated, when that's not what her training and experience tells her to do. There's 2 people between her and Haley Brown when she makes that determination. And then she leaves that ambulance. Haley goes from one ambulance, which we believe was the one that Mr. Brown was ultimately, his body was ultimately loaded into that ambulance. Miss Brown leaves that ambulance, and you can see on the video, I mean, the fire and rescue first responders that were out there, they were They were holding her hand to help her up and down and out of the ambulance. But she didn't have her arm around anybody stumbling or anything like that. It was a step up. You can watch that. That's in evidence. All that's in evidence for you to look at. Now, once she steps out of that first interaction, then what you have is some firefighter, somebody in that ambulance breaks medical protocol and tells Haley Brown, and this is not to garner any sort of sympathy with you or anything like that, but the state is trying to offer her behavior up to you as substantive proof that she was intoxicated. Somebody broke medical protocol and told her that he was dead and sent her into a fit, a suicidal fit, which is completely inconsistent with Miss Melinda Sue Connor's testimony up here this morning, who had seen her at 7:45. Had also seen Jason Brown at 7:45 and was taking Jason Brown's keys and suggesting that Miss Haley Brown drive. That's completely inconsistent with that. So you have Officer Reprogel offering an opinion that she's not going to base on objective science. They're going to get that later. If she wanted that and she knew how to do it, Maybe it was chaotic. It was chaotic, and we talked about that during the jury selection. We talked about that it's chaotic in the ER on a Friday night, probably any Friday night. But, and you can go back and watch this video as well. 48 minutes after that wreck, Miss Brown's is in a hospital room with a tourniquet on there. There's blood being drawn from there. If you were trying to investigate that, whether you'd done the horizontal gaze nystagmus or the 9-step walk and turn, let's just assume that this was not a situation where Sergeant Reprogel could have done that. It might have been a good idea to take a look at the fact that there may have been some evidence there. Because one of the other variables that General Arnold forgot to mention to Agent Bramlage when she was testifying about this magic number that they want you to buy is the existence of a second sample. She said it. The existence of the second sample, what Miss Brown ate. There are all sorts of other variables. He only gave her one, and that was the fact that there was no drinking for a certain amount of time. That's not the only variable. Now, okay, now we're back and we're at the hospital. Sometime after, and it was around 8:29 p.m. And that's in evidence. That video's in evidence. You can review it if you want to. Right around 8:29 p.m., and I apologize, I go from military time to regular time. I hope everybody can convert. But at 8:29 p.m., almost on the dot, that is when she is set off by that. She's on the phone, hearing who knows what. And you heard Miss Brown. I'd like you to, Miss Brown testified that she was repeating what people were saying to the video. The video will confirm that. You were drinking. Yes, I was drinking. You're in Dixon. Yes, I'm in Dixon. You can watch her repeating back what people are saying to her. You can see that over and over again. So who knows what was said to her on that phone? But here's what we do know. She became confused and thought that her dad was dead. We don't know why or how, but we do know that she was pondering a traumatic event where he had tried to commit suicide. And this is not something that she's come in here and made up. If she was going to do that, again, she would have come in here and said, hey, he jerked the wheel. It wasn't my fault. She's not doing that. She's here to tell you the truth. She's here to tell you her truth about what happened. And you've heard from her. So between 8:29 p.m. and 8:47 p.m., sometime around 8:47 PM. This is 18 minutes after she's been set off. And that's when the blood draw occurs that we never find. No dispute that that could be the best evidence of whether or not her BAC was. That would be the best evidence of what her actual blood alcohol count was. And we didn't get it. And I'm not saying whose fault that is. The hospital told Sergeant Summerer they didn't have it. It wasn't looked at. It wasn't followed. Instead, what did Corporal Reprogel do? Instead of advising the medical personnel on the scene, or I'm sorry, at the hospital, that a first responder on the scene had set her off, she took it on herself to try to set her straight, which set her off again immediately. And then she breaks into just these blood curdling screams, and she goes suicidal right there in the hospital. So as far as this being proof of intoxication, you heard from the doctor. You heard from the attending physician. And I'm going to play that for you real quick.
Okay. Just so real clear, EMS told her about the death already, okay? So I told her it was not her dad, it was her boyfriend. Well, this guy, he's like, oh, we don't tell people about their boyfriend dying in an emergency, there's blah, blah, blah. I was like, EMS already told her. He's like, okay, and they shouldn't have done that. I was like, okay, well, yeah, I was like, I don't work here. How am I supposed to know your rules? And he's like, well, we don't do that. Blah, blah, blah. I was like, okay, anything else? He's like, no. And he just turned it off. And that's why he came in there like that. Goodness. And I agree, he and I shouldn't have said anything, but they did. And she knows someone's dead. And she thought it was her dad. And she was screaming. So like, yeah, I was like, you didn't tell your dad. I mean.
So like I was telling her, we don't confirm a local staff in the hospital. I don't know which one of your partners told her, I'm not mentioning. I don't know which one of your coworkers told her, but her husband and whoever's there before here.
It was the EMS worker.
Yeah. Okay. Who are they to confirm that? Don't say, hey, your boyfriend's dead in the room, we're investigating. We don't.
Okay, well, like I said, she was aware of that when she came in here.
I'm aware of that. I
Okay,
saw her when she came in.
okay. Then I don't,
Don't stop talking.
no, I'm not gonna stop talking. It doesn't work like that.
It does, this is my emergency fund.
Okay,
I'm gonna stop, I'm gonna finish.
okay, you can finish.
Do not confirm that, because people don't know what's going on. And when there's a lot going on after a car crash, or somebody died, and they're already freaking out, and they potentially need an exam, you don't go in and confirm somebody's dead when they're already emotionally distressed. You let us, it's our job, do that. You
Okay,
can do your investigation, but don't confirm that. That is our job. She's now still distressed, and I cannot get her to agree to an exam, and she's not in a right mental state of mind where I feel comfortable discharging her and putting her because of that.
okay, good.
You hear the doctor say she's not in the right mental state of mind because of the distress. That's a medical opinion right there as to what was going on. Which would explain totally the difference in her demeanor from the time Melinda Sue Connor saw her until the time she gets into that emergency room. There's a medical opinion right there telling you that. Now, in General Arnold talked to you quite a bit about the instructions that Judge Wolf is going to give you there. And I want to, well, and I apologize. Later on, Sergeant Summerhour comes in. Sergeant Summerhour comes in around the time that Miss Brown's mother had arrived. Well, you heard testimony from the initial witnesses that were on scene. She's grasping for anybody that she can grasp for. She's frantic. She's panicked. All she wanted was her mom. She's screaming. She's suicidal. And right before Sergeant Summerhour comes in and she cooperates, who's there? Her mom. All she wanted was for somebody to console her. She was cooperative. They said she was cooperative. Cooperative at the interview, signed the implied consent form, gave them the blood willingly. But again, and going back to the instructions, you have to show that her intoxication was the proximate result that caused Jason Brown's death. Again, you can do the math if you want to. You can buy the math problem. You can look at it and see that there's errors on the face of it. You can see that there were variables missing in the testimony given by Agent Bramlage. You can see that, but you can do all that, and then you can still turn around and find that she was above a 0.08 at the time she was driving. You can do that if you want to, but you still have to take that intoxication and attribute that's it. Beyond a reasonable doubt that intoxication caused his death. It can be there, but it still has to be beyond a reasonable doubt that it caused the death. And you'll get that instruction. And the only expert testimony that we've got as to what caused that death, the only scientific, credible testimony would be Major Christian telling you that speed caused that accident. And I would submit to you that speed had nothing to do, based on her recollection of the events, based on Melinda Sue Connor's interaction with her, based on what you see has been offered to you as proof of her intoxication, was poorly mishandled scientific investigation of DUI, and then a broken medical protocol that sent her into a state of shock to the point to where she couldn't even be discharged by her own doctor. So if that's reasonable, if that's beyond a reasonable doubt to let the mind rest easily, I just don't see that. Now, with respect to the reckless conduct, again, we can't dispute that credibility of him. I mean, the speed is what it is. That's science, and that was science that had hard numbers. Hard numbers. No variables we could plug in there. So nobody's asking you to make a verdict. Nobody's asking you to feel sorry for Haley Brown. I'm not standing up here asking you to do that. Haley Brown feels sorry for herself, and I'm sure she will, but I'm not asking you to do that. What I'm asking you to do is apply the facts to the law and come to the determination that she's not guilty of vehicular homicide by intoxication, as that is not the proximate cause of this accident. I thank you for your time.
Mr. Arnold?
I just want to address a couple of things that he said. By a couple, I mean more than two. Sorry. So he says that I plucked one of the possible variables out to feed to Special Agent Forensic Scientist April Bramlage. The variable he's talking about is how long Miss Brown went without drinking. And he's right. I did give that variable to my expert, who was able to use that variable to give you more information about Miss Brown's VAC level at the time of the wreck. Here's why I grabbed that variable. We know that 100%, that from 8 to 10:48, she didn't consume alcohol. The reason why I picked that variable is because that's more than beyond a reasonable doubt. That's absolute certainty. Because we've got an officer sitting on her that entire time with body camera on. So I didn't just pluck it out over all the variables I could have talked about. I picked it because it's the thing we have the most certain knowledge of. And so it was the most informative for the expert to be able to use. Now, and I don't think math is magic. I actually think we can rely on math. I think that 16 is twice 8 is something that you guys can take back there, and it's absolutely beyond a reasonable doubt. The idea that to make it sound like some kind of hocus pocus just blows my mind, okay? So 16 is twice 8, I'm gonna suggest that's not in dispute. 3 hours of not drinking, I'm gonna suggest to you that after, especially the defense witnesses, that's not in dispute. So the reason why those things were selected is because they are rock solid absolute proof. Okay, now I want to address proximate cause because it's confusing. It's difficult. People have a hard time with it sometimes. Okay, so what I'm required to prove is that except for Haley Brown's intoxication, we wouldn't be here today, right? This wouldn't have happened. Jason Brown wouldn't have been killed. I am not required to prove that there are no other things that had to happen for him to be killed. Everything that happens to you, to me, to anyone from one day to the next has more than one proximate or but-for cause. If my alarm didn't go off this morning, I wouldn't be here. I also wouldn't be here if I got run over by a bus. So for him to suggest that because Miss Brown's fast driving is one of the things that caused the wreck, and that means that her alcohol intoxication isn't also a cause, is a mistake. It is a confusion. It can be true that but for her going 58 and a 30, he'd be alive today. And be true that but for her being intoxicated on alcohol and marijuana, he'd be alive today. I'm only required to prove the second thing. In reality, I think the case proves both things. I think the intoxication is the absolute best explanation for not only the speed.
Counsel's opinion.
Saying counsel can argue the facts to you, but cannot give you his personal opinion. So Mr. Arnold, refrain from your personal opinion, please.
Sorry about
The
that.
jury will disregard that.
Let me rephrase that. The proof in the case has given us a very good explanation for for the way that vehicle was being driven in the form of symptoms of intoxication and what those symptoms do for driving. They cause distance and time perception problems, motor coordination problems, problems with perceiving speed, problems with decision-making. Driving faster than you ought to drive, than a person ought to drive, is an example of a poor decision. Our toxicologists explained that intoxication causes poor decisions or can cause poor decisions. So the point is that the proof shows that speed is a but-for cause and that intoxication is a but-for cause. And just because one of them, speed and recklessness, is a but-for cause of colliding with the pole, doesn't mean that intoxication doesn't also play a necessary role. This kind of causation, you can have more than one. The state is only required to prove that intoxication is among them. That is all I'm trying to say. Now, in terms of a lot of this, it's not one of the elements I have to prove that Ms. Brown was not upfront, honest, cooperative, and truthful. That's not an element of this offense. It's not an element of this offense that I prove that there wasn't an event that caused friction between her and Jason Brown that night. That's not an element of this offense. Those are entirely red herrings. It is not an element of this offense that I prove that Sergeant Chandler wasn't confused at some point about what was or was not told to him by Haley Brown. Though I think it's pretty interesting that the thing that the defense was so upset about him ultimately saying to Sergeant Summerhour, namely that she'd had 3 drinks, turns out to be exactly what she tells Sergeant Summerhour and Captain Christian in an interview 3 weeks later, which lends a little bit of credence to Sergeant Chandler's redirect response that a lot of people were providing him information on the scene.
There's no objection. Those facts are not in evidence that Sergeant Chandler ever got that information and that was ever linked up.
Ladies and gentlemen, you are the triers of fact. Therefore, you will recall the testimony. The argument that Mr. Spratt makes is that wasn't what the testimony is. And I'm going to overrule the objection because that basically lies with you as the triers of fact to remember what the testimony was.
It is not an element that the state is required to prove that the Dixon Police Department did everything perfectly. That's not an element of this defense. But I would like to come to the Dixon Police Department's defense in this instance. The suggestion that Officer Reprogel should have pulled Miss Brown out of that room and run her through field sobriety tests when she couldn't get permission to speak to Miss Brown about what had happened that night and drew that kind of fire from the ER crew based on that it defies belief. It's just not fair. It isn't fair. And I just want to point out that that's not fair to the Dixon Police Department. When I redirected her, you guys heard her explain that we allow doctors to complete their treatment before we start doing certain kinds of investigation. So it's not our job to jump in and start taking things from them, pulling people out of rooms until medical personnel are finished. I don't have to prove that Dr. Lippert was wrong when he said Haley Brown was emotionally distressed. That's not an element of this offense. Not only do I not have to, I don't dispute it. Obviously, you all saw with your own eyes that she was emotionally distressed. It's not an element of this offense to prove that Haley Brown didn't want to speak to her mom. It's not an element of this offense to prove that Haley Brown was not suicidal. It is not an element of this offense that I'm required to prove that she was not distressed. Those are all exactly the kinds of things that I was speaking to you guys about in voir dire when I picked this jury, when I was explaining that there are going to be things you're instructed that the state is required to prove beyond a reasonable doubt and things that we're not required to prove. And an enormous percentage of what was just said in that closing argument touch on things that the state is not required to make any proof about. Thank you guys again for your time and attention, and I know you'll do the right thing.
Judge, may we approach?
You want this on the record?
Maybe.
Maybe. It's not a yes or a no.
Well, not at the moment.
Not at the moment. And the damage to the defendant from saying that the argument that they would be merged.
That's a good question.
Ladies and gentlemen, first up, Constable. Well, give them the option. It's 17 pages. So. Record.
Judge, if you recall in the state's initial closing, the state made a comment to the jury. And that comment was, you're choosing between three charges. If you convict on all three, those charges merge, and Ms. Brown only gets convicted of one charge. That, I submit, is an improper jury argument. To the point, to me, it rises to a mistrial. For this fact, we've now told the jury, it doesn't matter what you do here. You got three charges to choose from. You can convict her of all three, and she only gets one conviction. I don't know how you unring that bell, because that runs counter to what the jury charge is. The jury charge is you're to consider each three charges individually as individual counts. Well, the state has effectively now planted in the jury's head, well, it don't matter what I do, she only gets one conviction. So if we're going to convict on one, we convict on all three, and it doesn't matter. Because that is a logical thinking. A logical person would say, if I convict on one, it doesn't matter if I convict on all three. And that's effectively what the state said, and there is no way to fix that, because Mr. Arnold has put in the jury's head. If I'm going to convict on one, it don't get no worse, whether I pick 1, 2, or 3 at this point. To me, that's a mistrial, Judge. That can't be fixed. Or in the alternative, I guess we have to craft, or allow to craft some type of jury instruction, because natural thinking to any person, hey man, if you're gonna convict on one, it doesn't matter. It's the same as 1, 2, or 3. Well, what would any rational person say at that point? Well, You know, if we pick one and you're guilty, it doesn't matter at that point beyond that.
Arnold?
Judge, the comment that I made in my closing that he's describing, I immediately followed up with, you are to consider each of them separately. The only import or meaning of the comment was, I did not want the jurors to think that a person could kill one person and thereby be convicted of two separately treated homicides. As Your Honor knows, as I know, having filled out judgments after these cases many, many times where juries have convicted of VH by intoxication and VH by reckless conduct. And then in the third count here, I've charged a lesser included of the first offense. If the jury finds the person guilty of all three of those things, all three of those things will merge. And not only in these vehicular homicide cases do I have that situation, when I charge alternate theories in DUI cases, when I charge the per se and the regular count, I've had jurors come back repeatedly and say, hey, that's confusing. How can somebody commit one DUI and be guilty of two? And I've actually, I think an instruction would be sufficient, Judge. I don't know that it's required. I've mentioned merger in closing arguments. I actually do not know how many times. So, I mean, if it's inappropriate and it needs an instruction, then by all means, I'll stop doing it. But I've not ever had it objected to before, but I don't think it causes mistrial, Judge.
Judge, if I can briefly, for the record, I would like you to think of it in this terms. I mean, we're talking about normal people. If you go to the grocery store and it's buy one, get two free, you don't go in and say, only give me two. So
On page 15 of the final instructions, of which both sides have been given a copy, the following instruction is given to the jury and will be read to the jury, and they'll have their own individual copy. The defendant is charged in 3 separate counts of the indictment. Although these cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and evidence applicable to it, just as though each case is being tried separately. You will be asked to render a verdict as to each count of the indictment. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your findings as to each crime charged must be stated in your verdict. That clearly and sufficiently, in my opinion, is a charge that defines for the jury their role and how they're to do it. Your objection is to an argument that was made in the first part of this argument. There was no contemporaneous objection made at that time. My proposal and my decision is that I will craft one short instruction over the lunch hour that basically says to the jury that I have previously instructed you that arguments of counsel are not evidence. Statement of the district attorney regarding the merger of any of the counts of this indictment is not evidence, and you are instructed to follow the laws that I give to you in the final set of instructions. And I'm going to read that to him before I begin the final charge. Your motion for a mistrial is respectfully denied. We will proceed with that one instruction, and I'm going to bring the jury in and send them to lunch so that we can get that done. And in the future, Mr. Arnold, I would suggest you not make that argument.
Apparently, Judge, sorry.
Well, the final instructions are what should be argued about those kinds of things, rather than. Anybody hungry? I am. We're going to let you go to lunch. I am going to give you a specific instruction. During your absence from the courtroom, I considered an issue, and I previously told you that the arguments that lawyers make to you, both in their opening and their closing, are not evidence, and they are not stating to you what the law is. I'm going to read you 17 pages of instructions on the law, and you'll get your own copy. That is the law, not what the lawyers make in their statements to you and arguments to you. There was something that was stated to you about a merger, and I'm going to give you a specific written instruction supplemental to what I'm going to read to you here, that you're not to consider that, not to consider what was said about merging those things, because that is my responsibility, how I treat those things, not the jury's responsibility. You're going to be instructed in these final instructions and in the written instructions I give you that you are to consider each count of the indictment separately as though they were being tried separately, even though they're being tried together. So I'm instructing you right now to disregard anything that the state may have said about merger. Put that out of your mind. I'm going to give you a specific written instruction when we come back from lunch and tell you that in addition to the instructions I give you in writing. So with that, we will be at lunch until 1:15, and that'll give you a few minutes extra, and me a few minutes extra to get this done. But at 1:15, we'll ask you to be back in the jury room, and I will then give you the final charge, and you'll be allowed to retire to deliberate. Now, I would remind you that we have 2 alternates, and luckily we have not had to use those alternates yet to fill in for somebody who had to leave. But when we read that final charge to you at the end of that time, I will select randomly 2 of your numbers that will be discharged, and you won't have to decide the case. You can stay and talk to the lawyers and let them know what your thoughts were, or you can leave and vamoose, so to speak, whatever you want to do. But under the circumstances, that will happen after I've read the final instructions. So we'll let you go to lunch until 1:15, and then we will see you back in the jury room at that time. We'll stand at recess until 1:15.
All rise. This court's now in recess until 1:15.
All right, you guys. So we are caught up to them, and the judge has already read the jury instructions, and there still isn't a verdict. So once there's a verdict, I will post it. So I'm going to end this one. Let's see. Hold on. RIP to Jason.